ইশারা অন্য কোথাও আছে কিন্তু পারবা না দাও एक बार हम देखने में कोई हाथ অন্য কোথাও কি থাকে না দাদা हमको जहां डाउट है हम एक बार देखने में क्या है अरे এখানে বলছি না हम সিরিয়াল সঙ্গে কি অন্য কারো দিলেন না
Hello, thank you, old teacher, and new teacher, and new. Alright. Good boy. Unmute.
आ रहा है आवाज आ रहा है
Okay.
हो गया काट दो
हाँ समझे हाँ
খেলে দাও তো এদিকটা। That's fine. Accordingly, WPCT 58 of 2025 is dismissed on contest, thereby affirming the judgment dated November 1st, 2025, passed by the CAT. No arrest for certain.
Any other directions?
Seconds. We have discussed in the body of the judgment. You go through the judgment. It will be uploaded as soon as possible.
I'm very good.
Because they also, if they want to prepare a challenge, we have to give them some time. So immediately it will be uploaded.
With challenge.
That is not in there. Definitely have a right.
Well, it's all that time.
Reply. Yes. Fortnight. Reply your. Yes. Reply your opposition. Opposition to their application.
Yes.
Yes.
Already there is an order of my lord.
Yes, and it has to come on record. Otherwise, the stand there, then again new stands will be taken. Obviously, Mr. Kumar will be in embarrassment. Not opposition, the problem. Learned counsel appearing for the respondents seeks further time to file the affidavit in opposition in the form of a report as directed earlier. So accordingly, the time for filing the same is extended for a fortnight from date. Full-stop. Let the matter be listed before the next session. Thanks. These extensions will be readily granted now because you don't have time to decide these matters. 3 days is not sufficient.
Here not passed by the time. I have found this one.
Correct. Yes.
That's not happy. Lord, it's a very. I just short back to my lord.
They're not enjoying any interim order.
No, my lord. The thing is that this person was appointed as a junior engineer in the year 2002. Under the service jurisprudence, his service ought to have been recognized in the year 2004. Now, my lord, he could have got the first MSCP in 2012. Now, what happened, my lord? There were a bunch of persons, several persons appointed together. Their service was not confirmed for more than 20 years. One of the incumbent approached the tribunal, followed by the order of this honorable court. This honorable court immediately confirmed the service, grant them all financial benefits. That has been granted. Subsequent to the order of the court, also only that person who approached the court got it. Others also approached the court; they also got. So far as I am concerned, my lord, in 2020, a disciplinary proceeding was initiated against me. On the set premises, my service was not regular. Given confirmation and benefit.
The disciplinary proceeding is still pending.
2020 disciplinary proceeding was initiated. My service ought to have been confirmed in 2004. I approached the tribunal after filing a representation before the authority. Tribunal directed to dispose of. Ultimately, they rejected. I approached the tribunal. Tribunal said disciplinary proceeding was initiated in 2020. You have to confirm his service in 2004. And the first MSCP, you grant these two benefit. So far as second MSCP, abide by the result of the disciplinary.
Mr. Kumar, what will be your
Now,
ground?
my lord, after that, my lord, I have challenged the disciplinary proceeding also before the tribunal on the ground of delay. And furthermore, at that given point of time, I was not posted. The court accepted both my argument and the court quashed the charge sheet also.
That has been challenged.
No, that was not challenged. That is another
So,
proceeding.
Mr. Kumar, then what remains in the
And my lord, what happened, my lord? I find a contempt. Notice was issued. That after issue.
We'll adjourn it for the day only.
Yes, my lord.
On the prayer of the appellants, the matter is adjourned for the day.
Right.
Regulation Yes.
Whether after retirement, administrative promotions can take.
Here it has been given.
Here it is.
Why not? I mean, what is your problem?
After retirement, when you are not substantial, not entitled to, because your funds were being retired, not entitled to many.
No, the benefits have been granted even during the period of retirement.
No.
Ah. Use the microphones.
He has been at the moment when the business process, UPSC has been considering in that case, but he could not be promoted. In the meantime, he has retired, and subsequently after his retirement, as income has been promoted. But the tribunal said, no, you are initiated for 2016, so you have to give its benefit from 2006.
It is date of superannuation.
Only DPC was initiated by the UPSC. That data has to be done.
Apparently, we are convinced against you. So, but the respondent is not there, so we'll give you the benefit of that. You have served on the respondent.
Service is not a UPSC.
Effect service. Here is the benefit. It is very. आगे challenge कोई तो आगे challenge कोई कोई positive eligibility promotion করে তাহলে কি সুবিধা কথা কিন্তু ডিল করা হতে পারে রাস্তা পরিচয় there is apparently service has not yet been effected on the respondents to serve. Accordingly, the appellants are directed to serve copies. The petitioners are directed to serve copies of the writ petition on the respondents, indicating that the matter shall be listed before the next party, the next survey. Which have liberty to mention before the next survey. Thanks.
But if I'm the respondent, but if this is a sale appeal option, and appointed by the state, along with revision, there are two brands, one for suspension sentence and one for section 5 limitation. 211 days delay option. I have explained the delay in my application option. It is only when I went to the jail for the function of jail cleaning, I could meet this person. I could tell him about rights after the certified copy was taken, and I have filed the appeal for this one. I create or secret section 5 of the order. After the letter, I will take the judgment of it.
You are allowing the section 5. Yes. Thank you. Definitely. The reason for the delay in filing the appeal, as explained in CRAN 1 of 2026, is that the petitioner was behind the bars, and only when he went to the jail, only when he attended a jail clinic program organized by the District Legal Services Authority, the learned advocate of the DLSA informed the convicts about their rights, upon which the appellant chose to exercise such right by preferring an appeal. The subsequent time was consumed in taking out certified copies and preparing the appeal. Upon hearing learned counsel, we are convinced that sufficient explanation for the delay has been given. Accordingly, CRAN 1 of 2026 is allowed on contest, thereby condoning the delay in preparing the appeal. Yes. What about?
There is stand to logic, which is for suspension of sentence logic.
What is the offense?
Offense sentence 3A, 4, 5M, and 6 of POCSO Act. I've been convicted for 20 years, and a final rupees 10.
How much have you spent behind the bars?
From the day of reception of this affair, I'm in custody of him.
Period.
3 years and 6 months. I'm in custody. from the very day of the inception of that.
Now, the state will have a point that the position is different before conviction and after conviction. One competent court has convicted you.
Yes.
So, what do you say to
You know,
that?
this instant case, without going.
But your ground has to be on a
Yes,
higher
yes,
footing
yes,
than
yes,
normal.
yes, look, but if this instant case, presumption of, according to section 9 or presumption, they have convicted me. In an other case, my lordship was pleased to say that for presumption, the foundation facts needs to be very clear. And in this case, the foundation facts are not. The medical evidence has completely gone different. And in the medical evidence, in the CFSL report, there is no whisper of any. Sorry, I will just take to lordship to page number 42, lordship. 42 of the page number 42. Lordship.
Yes.
Point number 10.8, lordship. I will just read out. In the case in hand, there is an allegation that the active content is finished in the mouth of the VG, and as per medical examination report of VG, which proved exhibit T5 by Dr. Supriyo Roy, the opinion of doctor reflects that neither genital nor physical injury present, suggestive of no use of force, however, sexual assault not ruled out.
What was the age of the victim?
4 years and 6 months.
4 years, she might not be able to resist.
No, let me. Just he was a baby. Just see the report will.
What is your age?
37.
Well, please continue.
Yes, that's it. Be that as may be, the absence of injuries does not necessarily mean that no assault occurred. The absence of physical evidence or injuries does not negate the possibility of sexual assault. Sexual assault can occur without leaving readily apparent physical trauma. The forensic examination aims to gather all available evidence, including both physical finding and the victim's account, to provide a comprehensive picture of the event. The Dr. PW6 also collected oral swab and the VT of the semen examination and DNA test, which was sent for CSO examination. Prosecution examined the sequence report exhibit 13 through Sub-Inspector David Patnaik, the charging officer in the case. Now, when the sequence report prepared by Mrs. Sunita Bhattacharya, Junior Scientific Officer, Bio CFSO, Kolkata, is scrutinized carefully, it appears that in the conclusion portion there is an observation that human semen could not be detected on exhibit 10A oral swab and 10B filter clothes. The biological fluid material present in the exhibit 10A oral swab and the dental cloth belong to the same female individual, that is the VG in the case. Although forensic examination of the mouth can identify the corroborative allegation of sexual assault, forensic medical examination should be conducted according to established guidelines and protocols to ensure accuracy and consistency. Studies on biological evidence in other fluid shows that the male DNA can be detected in the female saliva even after 60 minutes. Good deletion rates decrease over time, and spermatozoa which contains DNA can also be detected in oral swab for up to 8 hours after an assault. Now, as per the prosecution case, the incident occurred on 21/12/2022 in between 7 p.m. to 7:30 p.m. and as per exhibit P5, VG was medically examined at 2 hours, that is after 6 to 7 hours of the incident, and medical examination occurred at 2:45 hours. That means the VG was examined and samples were collected within the 8 hours of the incident. But the CFSL report is not supported in the case of doctrine. In the actual, no scientific or no expert or scientific officer has examined. Clear case, clear.
Yes.
That's a, this is the main. This is my one of the main points here. Now, I'll take to logic to page number 46. Logic page number 46.
Yes.
Paragraph number 10.2. Now, to ensure the just decision of the case, it may be mentioned that PW to the complainant come eyewitness in her evidence has stated the presence of street light on the road, footpath, drain, and banana tree situated at the place of occurrence, where accused was found committing sexual assault under the VG. On Metropolitan perusal of the sketch map prepared by PW towards the IU, I find no indication of having any street light, footpath, drain, or banana tree in and around the view. There is indication of how the Amrit Sarkar in the side front, which is located at a short distance from the floor, but neither Amrit Sarkar nor any member of the house were examined in this case. In this case, no independent witness were ever cited in the charging. In this case, the VG has named one Dadu here, but the test identification for it was never done. Even the 164 statement were never executed before the trial. The PW who happens to be the eyewitness has literally stated two different versions here. In one version, she says that the accused came in his house,
she has seen the assault and she has called the police. And in the cross examination, she says, I will just take to page number 30, Lordship. Page number 30. This is the cross examination, Lordship. I will just in 8.6, from the bottom 12th line. She saw the accused for the first time prior to the alleged incident. She did not know the state person prior to the date of the incident.
No,
He was
8.6 near bottom.
Lordship, 12th line from bottom, Lordship.
Acha, she saw the accused.
Yes, she saw the accused for the first time prior to the alleged incident. She did not know the state person prior to the date of the incident. He was a stranger to her. She do not know the reason for which the state person came to South. And in chief, he says that the accused person came in his house. He was feeling hot, so he went outside. I don't know how these two contradicting statements have come before this honorable. But apart from that, the doctors, I'm grateful that this medical is there in the also. The doctor who has done the medical examination of the accused person has stated that he has collected the wearing apparels, the underwear of the accused person, but there was no traces of any saliva of the victim. This is again one of the my points here. And apart from
Underwear
that,
of your underwear.
yes, sir, accused person. And Lordship, it is also stated that the his opinion was he has not performed any sexual intercourse and that in the last 24 hours. Kindly appreciate a phenomena wherein if a sexual intercourse is done by an accused person,
It is an allegation of penetration in the mouth.
but your what we say, Your Honor, there are some powders near the finish which gets dissolved at that into. But at that time, that were present at the medically, the foundation facts, Your Honor, the medical is one of the very important proteins.
No, the last point you couldn't understand. You said that you did not perform any sexual intercourse.
Yes, sir. It is allegation that I have penetrated in the mouth.
Yes.
It is always that when a sexual intercourse takes place,
Yes.
the white particles around the penis gets dissolved. But at the time of medical examination of the accused person, the white particles were found. That means there is no sexual intercourse happened in the last 24 hours.
That is going too technical at this stage.
And-
You are not convinced.
Yeah. The CA person report that was come before this honorable court, that is one of the main. Kindly appreciate, Your Honor. Apart from that, all witnesses are hearsay witness, Your Honor.
CFSL report was there. It was not found that
And it was done within time limit also. Kindly appreciate.
6-7 hours after.
Yes. And with this complete period of 8 hours. Anti-judicial must have this famous suspension of sentence or
Yes, let us hear the public process.
Also, regarding this page number 42 of the
Yes.
there are 10.9. It is observed by the trial court that what was the reason? Penetration in which place, that has to be seen. That is a very
Obviously, oral and
yes. That is
might have been swallowed.
what, yes.
6-7 hours after.
Internal, whether any other examination was done upon the victim, taking some fluid or some of the stomach or nothing else. Only basis of the DNA, that whether it was presence of the particles in the mouth, that was negative. It doesn't mean the offense was not committed. And we cannot forget the age of the victim. Any enmity? What was the reason for false implication? Why a mother of the victim, that is 4 years, so she was just a baby. We could have been just 4 years.
Murder.
No, mother of the
Mother.
of the victim also examined. She categorically stated that how she the accused has badly assaulted, sexually assaulted.
No.
He is the main active witness.
No. Eyewitness is not the mother. Eyewitness is the your neighbor. Mother was the yes.
Complaint.
Rahima Bibi was the
But
complainant.
other
He was the neighbor.
witnesses seen who is the neighbor. If that be so, Toshi, kindly come to the page number 43 of the informed judgment. Para 10.28, last paragraph.
Yes.
Page number 43.
Yes.
I will have read out actually what he has done there. Can you see the word? Being a 4 years of baby, I think this sentence is sufficient to establish the strong prima facie evidence against the accused person. Nothing more is required. I never expect that some other strong evidence has to become from the mouth of the 4 years baby. So at this stage, seeing the gravity of the offense,
Heard learned
nothing
counsel.
can be tried.
Just this one. But this is a medical exam chapter. I was not covering the word. Because the smegma. Smegma is a thing which is present at the penis, and at the time of sexual assault is the best of. But when after there was a presence of smegma, it is transpired that there is no whisper of any medical any assault. This is the medical assumption.
Smegma would be fine.
In the point number 4, presence of smegma.
Acha, please. Great. Heard learned counsel for the parties on the application for suspension of sentence. This is learned counsel for the appellant stroke petitioner submits that the appellant is already in custody for 3 years and 6 months. With the next para. Although presumption was raised against the appellant under section 9 of the Protection of Children from Sexual Offences Act, 2012, it is contended that the foundational facts to establish such presumption are absent in the present case. So it is submitted that the principal component of the charge, being the CFSL report, disclosed that the examination did not suggest performance of recent sexual act, within bracket no bodily genital injuries, plus presence of smegma, SMEGMA, plus absence of vaginal stroke female bodily cells, bracket closed. So thus, it is argued that there was no proof connecting the appellant to the offense at all. So next para, learned counsel also seeks to point out that there were several discrepancies in the evidence of the supposed eyewitness. So next para, learned counsel takes us through paragraphs 10.8 and 10.9 of the judgment of conviction of the impugned judgment, from where it transpires that the CFSL report neither disclosed any genital or physical injuries present, suggestive of no use of force, as well as human semen could not be detected on exhibit 10 capital A within bracket oral swab and 10 capital B within bracket dental floss. So next para, thus, it is submitted that the conviction was based entirely on conjecture and without any evidence. So next para, it is further argued on behalf of the appellant that the doctor who was examined, stated in his evidence that there were no traces of saliva in the underwear of the appellant, thus suggesting that there was no instance of sexual act by the appellant at all. So next para, furthermore, it is argued that the statement under section 164 was not exhibited, nor was there any independent witness. So as such, it is submitted that due to the gross discrepancies of the eyewitness, the appellant, there is sufficient doubt as to whether the presumption under section 9 could be drawn against the appellant at all. So next para, learned public prosecutor seriously opposes the prayer for suspension of sentence and contends that in the facts of the case, which were elaborately discussed by the learned trial judge, there is no scope of there being any doubt in the factual premise connecting the appellant to the crime. So next para, learned public prosecutor points out that the learned trial judge fully took into consideration the fact that the medical examination took place after 6-7 hours of the incident, and as such, comma, keeping in view the region where the alleged penetration took place, comma, that is the mouth of the victim girl, comma, it might very well have been that no traces of semen was found at the relevant juncture. Which sub next para it is further argued that the court ought to consider the tender age of the victim at the time of the offense, comma, being about a little more than 4 years of age. Which sub next para, accordingly, comma, it is contended that the prayer for suspension of sentence ought to be turned down. Which sub next para, upon carefully perusing the relevant portions of the judgment and the copy of the CFSL report handed over by learned counsel for the appellant for our perusal, comma, we do not find any patent illegality or gross irregularity in the impugned judgment sufficient to mitigate the rigors of the conviction. Full stop. Next para. Insofar as the absence of any vaginal stroke female bodily parts and stroke or traces of traces of semen is concerned, comma, there was no scope, there was little or no scope of the same, comma, since the medical examination of the victim girl took place 6 to 7 hours of the incident, and keeping in view and taking into consideration the region of the alleged penetration, that is the mouth of the victim girl, comma, it might very well have been that all traces, comma, even if any at the time of the offense, comma, had dissipated. Which of next para, secondly, comma, to constitute the offenses as alleged and on which the appellant has been convicted, comma, a sexual act or ejaculation is not a prerequisite. Full stop. It would be sufficient if penetration in the mouth was proved by the evidence on record. Full stop. In the present case, comma, we further take note of the fact that the victim girl was of very tender age, comma, being just above 4 years at the time of the offense, and the mere lack of suggestion of any use of force or resistance on the part of the victim girl can easily be ruled out, comma, since a 4-year-old minor girl is not even capable of raising any resistance worth the name. Full stop. Next para. Insofar as the submission of the appellant that there was presence of smegma, SMEGMA, is concerned, comma, the same does not does not inspire confidence in us to hold that the conviction was based on surmise, comma, since, comma, as we discussed earlier, comma, it is not necessary that the act of ejaculation or sexual activity was necessary for proving the nature of the crime alleged against the appellant. Push up next para. The discrepancies sought to be pointed out in the evidence of the eyewitness were of a minor nature, and it is well settled that the truth of the evidence cannot be shaken merely due to certain discrepancies, semicolon, rather, comma, a truthful witness would be more prone, PRONE, to have certain minor discrepancies at the time of narration of her version. Full stop. Next para. The court is not unmindful of the fact that the the appellant is already in custody for more than 3 years. Full stop. However, comma, the considerations in a post-conviction application for suspension sentence is much stricter than a pre-conviction consideration of bail. Full stop. Next para. In the opinion of the court, comma, the appellant has failed to cross the hurdle of such strict standards and we are of the opinion that the appellant is not entitled to being enlarged by a suspension of his sentence, more so keeping in view the fact that the victim girl was a minor of tender years at the time of the offense, and the gravity of the offense was too high for us to grant such relief to the appellant. Full stop. Accordingly, CRAN 1 of CRAN 3 probably. Two. And CRAN 3 of CRAN 2 of 2026 is dismissed. Full stop. আচ্ছা এটার আগে CRAN 2 এর আগে আর after the condonation and before CRAN 2, right? The appeal is admitted and will be heard on the grounds taken in the memorandum, which the issue. Yes, victim the complaint defective. Issue usual notices, full stop. Paper books be prepared within. Trial court records be called for. Paper books be prepared within 8 weeks. 4 weeks. Within 4 weeks from the date of arrival of the trial court.
Alright.
Can we keep a copy of this on record or
I will give a copy.
give up?
It's suspension sentence needs to be heard after service to the VT.
No, we are dismissing at the outset. If you allowed it, you are right. At the exception, we can use the word rejection if you want. এটা আসবেই না, ভালো লাগছে না দেখতে। এই আমার লিস্টে চলে গেছে ওটার সঙ্গে স্টিফেন।
Ago, I have received the service confirmation before. I could not able to prepare the so there are two CAN application.
Oh, one second.
The appeal is 18 days delay by filing application as section 5 of the limitation. And with the compliance of the last order, I
The limitation, if I soft copy of the section 5, we are directing with that.
no, yes, that I have said.
Yes.
I have received the service confirmation report just now. So
Oh,
I could not able to prepare the application.
so should we take it up on Monday?
I will file the application service.
Wait, we'll take up the section 5 along with the order for 10. Come prepared on the order for 10. If you allow the section 5, we'll take up the admission
The
hearing.
application as well as the.
Yes, order for 10 after that stage.
Yes.
If you admit at all.
Yes.
On the prayer of the appellant, let the matter stand adjourned for the day. Appellants.
That liberty may be given to file a affidavit of service.
No, you'll file on the next day, we'll record that. We're not saying anything. Those of you who are present here, we are just indicating, when possible, please just communicate to the board that we propose to, when we dice at 12, after division bench, after 10-15 minutes, we'll immediately sit in single bench. And we'll sit according to our, as far as my single bench is concerned, I'll continue up to 2 and end there. Because to cover up the time, so that we don't have to sit till 4:30, because we have to wrap up also the previous judgments. So we'll 10-15 minutes break, then up to 2 for my bench. And Justice Das's bench, she'll express when she sits in. Thank you very much. 7, not today. No order need to be recorded, no. Not today, next circuit. একটা order record.
Not today.
No, not today, not.
Next Sunday.
None appears at the time of call, full stop. Since only 2 days are left in the present circuit, comma, let the matter stand adjourned till the next circuit. Hearing whatever.
And for the petitioner, take time, madam.
Hearing,
No, it will not take, I'll take only 5 minutes.
I will take 2 hours, madam.
Because
he's deliberately doing it.
last orders, please come to the last order.
Mr. Dicruz, we have,
Every circuit, they are taking time.
No, we are not taking
No.
time.
court is taking time.
No, my lord.
Mr. Dicruz, we are telling you, we are telling you, we are telling you, we are telling you, Mr. Dicruz. We have been taking up several matters. We already have several, you have been present all through. So you know because it will not be possible for us to take up and dispose of matters, hearing matters.
The thing is, neither the petitioners nor the private respondents have given promotion based on the improved scenario. They still take. But
If there was urgency, you should have mentioned, because some people mentioned at the inception and we have put it on the top and heard it.
Once in the year 2025, challenge is order.
No, last 3-4 days won't do. Last 3-4 days, what will you do? For when we started sitting, from then on, for the first entire 2 days of the first week, at least 3 days of the second week, you have taken up mentioning. So after that, if you come into the zone of no consideration, like the CRZ things. See, you come within the coastal region when you leave the islands.
not to give any effect to the improved scenarios. This is the outcome of this.
Impute scenario.
Yes.
Is it possible, Mr. Dicruz? It
Yes,
will
outcome.
throw the entire system into topsy-turvy.
My lord, I tell you, I'll explain. This case was first filed in the year 2020.
At best, abide by result.
So that also cannot be right, madam. But this order was passed in 2025. They approached the court after a delay of 3 days, 3 years. Delay and a merit it was dismissed. And now my landed fund has filed this WPC.
No, delay as well as merits.
Both.
Cannot be.
So delay, well, delay was one of the
Cannot
parts.
be. If you dismiss on delay, then on that ground it should be allowed.
My
No,
lord,
delay was there.
No, Mr.
It is incorrect.
We'll hear it only on delay.
Yes.
Because Mr. Viriko, we are telling you clearly that if I hold that I rejected as time bar, I cannot touch the merits. Settled principle, all of you know it. So then we'll have to hear it on the delay only. What was the delay? 3 years.
3 years delay.
No, my lord, this 2025 matter. And
Not here, in the tribunal.
in the tribunal, in the 2025, this order was passed. Actually, what happened? First OA was filed in
2016 seniority, 2022.
2016 seniority and
Provisional
2020.
seniority is 2016. My lord, challenge me,
My lord.
made a representation in 2019. That was rejected in 2019. Thereafter, final seniority in 2019, he challenged it 2022. Dates are also there.
I can give the list of dates.
What was the reason for the 3 years delay, Mr.
Lord, this provisional seniority list of 2016, we have made a representation, and my representation was rejected on 10th of July 2019.
Representation made on 16th April 2019.
Yes, that was considered by the authority, and it was rejected on 10/7/2009. The very next day, on 11th July 2019, the confirmed seniority list was issued. Thereafter, immediately no representation could be filed because of COVID. After that, there was a COVID period of 2 years.
COVID started from the election.
24th March 2020.
March,
It was 11th July
it
2019.
was 28th. First
March.
15 March.
24th March 20.
15 March.
No,
That's
24th.
No, 15 March 2020,
some motto case is there.
and ended in the
And
last part of
28.
21.
28 February
August
2022. 28 February 2022. That is in so motto case, it is clearly.
So what happened between this July 2019 and March 2020? There were 8 months in between.
No, thereafter, my lord, it was filed on 22nd of October 2020.
Thereafter, I have made my protest against the confirmed seniority list.
in the month of October 2020.
Then
October 2020.
why?
Then
See, Mr. D'Cruz, you have to explain two delays. One is these 8 months between July 2019 and March 2020, and this another 8 months between February 28th, 2022 and October 25. What is the explanation?
after that,
No explanation.
Not after. What was the explanation for that period?
I have given in my written argument before the tribunal itself. In that it is mentioned.
Discretionary relief, it has been refused. Why should it?
The judgment. Shiv Kumar.
But every section 5 has to be allowed.
No.
Yeah.
It is not like that, my lord. Because in seniority list,
We cannot enter into the merits.
No.
And we'll say that the observations of the learned tribunal were without jurisdiction. Only on the ground of delay
Only on the ground of delay.
we'll sustain that. Yes. Unless you prove why you were delayed.
My submission for the tribunal is 573, page number 573. 570.
Now let us see how the tribunal dealt with it.
Tribunal has not dealt with this. My submissions are not recorded in the tribunal. That is my given. I preferred a review, and review was also dismissed. So in this
You are challenging the review order
review and
both in a single writ petition.
Yes. I came after the review. It was done within a month of.
No, then you have to put in 2 court fees because otherwise 2 separate writ petitions at first have been filed. Review and
Jointly.
very well we can direct you to put in additional court fees for that. That is a technical detail.
574. Page number 574.
That is your arguments,
Yes.
notes. We are wanting to see the tribunal's order.
Yeah, I will come to that. This is the issue on limitation. I have explained. 574. Issue of limitation. Last part.
Yes.
This what happened. This what I have explained. Everything is there. Therefore, the effective delay comes to be 1 year.
No, in a written note of argument is not your pleading. In your pleading, what is the ground?
What happened, my lord?
Pleading is
My lord, that my representation was disposed of.
In your OA, was there any MA separately filed?
No, my lord. Because when, as per
There was no section 5 condonation application filed.
as per section 21 of Tribunals Act,
Yes.
Tribunal
Has jurisdiction.
I have to,
You gave the explanation in the main OA.
my lord, I have to approach the tribunal within 1 year from a rejection. That is the law. My representation was rejected on 5th of March 2023, and I have approached within 1 year, within 1 month. After rejection, within 1 month I approached the tribunal. So there is no need for any explanation.
Within 1 month, please?
5th of March 2023
Yes.
was my rejection by tribunal, by the authority. The representation which I had filed.
5th of March 2023.
5th of March 2023.
What are you saying?
Can we see para 10 of the judgment 463?
I have given here 15th March 2023 para 10 in this written submission in March 2023.
463.
That is under challenge. That is under challenge. My lord, please look at this document.
Yes.
Rejection order.
Or you say that limitation calculation, that period should, obviously the COVID period has to be deducted.
Oh, and the authorities.
No,
it was-
Mr. D'Cruz, you are making a cardinal mistake, a basic mistake. For that relaxation of the Supreme Court orders to be given, the limitation had to be, but you say the limitation was still running, right?
Limitation was running.
Right.
I prepared a
Yes.
petition against the unconstitutional.
Right.
And that was rejected.
But you had lost 8 months before that. So that period you will get extra. So after that, you will not get a fresh 1 year after February 2020.
2 months I have come to that. I will just take you to that rejection also.
Rejected on 5/1/2020.
Page number 168. January.
Has been.
January 2023, 168. Page number 168, sir. Page number 168.
168.
168.
What is that?
That is my rejection order by the authorities.
No. We want to see the judgment of the tribunal, impute judgment
Page
first.
463. No, that.
We'll see that first, Mr. Cruz. Please. We'll see the tribunal's order first before looking into anything. What is the page number?
Page 463 is the relevant. It starts from. That's from page 440. Even to 463, where the tribunal has dealt with the delay part. 450. This starts. Yeah.
Mr. Kumar, this requires a bit hearing because on the limitation question we have to hear. Mr. Dikkus, we are not taking up this side.
That's why I'm saying.
We are not taking up this side because we are telling you frankly, we may hold in your favor regarding the limitation. If you do that, we may or may not, but if you take it up, you may have an arguable point regarding limitation. If you do that, we have to hear it on merits, which will not be possible with this side.
1,000
No. If we had time, we would give you ample opportunity as we have given to others also. We have nothing personal against you, but in 2 days we can't do it. It's our fault. If you want, we can record that in our.
At least we can cross over the limitation point and give us the.
No, how can we do it?
Oh.
Has to be taken up. If it was a limitation for this repetition, we could have understood.
No.
If you take up limitation, you have to touch the other point.
Because tribunal has not recorded in that part that rejections by authorities are on 5th of January 2023. That is not recorded there.
At the outset,
It is there.
it is there.
Kindly come to page 557, sir. That the said representation was rejected on 5/1/23.
Right. Yeah, claims do জায়গা দিয়েছে ও। হ্যাঁ, এটা তুমি নতুন করে রিজাল্ট করতে পারো। If you took up the matter 2023 may not be of relevance because you cannot revive the limitation once it's over. But regarding the pandemic period, we'll have to make that calculation and see whether that was available to you. Limitation.
That is within 1 month, 2 months, 3 months I have approached.
মাস আরো থাকছে 4 মাস আরো থাকছে ও করলো ধরো 8 মাস করে সেটা কি মাংস সেটা খুব
এটা modify করে।
4 months না modify না যদি 4 months তাহলে পুরো কনসিডারেশন করতে পারবে আর এখানে কোনো অ্যাডভার্টি করেনি বাউন্ডারি 4 months হলে তো কিছুই দিবে না এমপ্লয়ি আসছে।
Actually, look separate applications MA is required.
No, that we are not.
Can you come to 592?
No, otherwise we were not expressing our mind because some other bench will take it because frankly speaking, then it would come to probably 4 months only. Then the 4 months delay only. Because you lost 8 years before pandemic period. After pandemic, you filed after 8 months. So 4 months, you would get more 4 months you would get. Calculating in that manner, you would get 4 months. We won't give you a clue now because they will suffer.
That these issues are already decided by Supreme Court delay part. Fine.
We need not go to the Supreme Court. This is we are sufficient for this.
So actually that.
Due to
One request, madam. Last occasion also I made this because I want to file an opposition to the preparation.
since you are getting time, file it in the meantime because
that's fine.
on that ground,
Yes, madam. There
Larry,
is an order I can file.
you're for the private respondent.
Private.
You want to file anything?
All records are.
All records.
on this,
Then counsel for the private respondent seeks to file an affidavit in opposition, full stop. Accordingly, the private respondents are directed to file their affidavit in opposition within a fortnight
Right.
from date. Reply if any, because you are getting the time.
Yes.
Full stop. Reply if any shall be filed within a week thereafter. Let the matter be listed for hearing before the next session.
One is no further time for reply. So this is the first time, my lord. Last occasion, my lord, see, because of the. They have taken time. No, never, my lord. Kindly see the last order, my lord. Because of the difficulty, one of the judgeship, my lord, that matter was not taken. My clients are losing the right because of this delay. And my lord, I am appealing for some of the private respondent, the order that it reflect, my lord. I will.
Ajay Dekhande bolla private respondent, the appearing private respondent.
Yes.
The private respondents who are appearing today, who are represented today.
My learner file is taking time every circuit. If you go
No, last circuit it was personal ground of one of the judges.
before justice, their appearance. Before justice Ajit Banerjee also.
Justice Devanshu was a case.
Devanshu Prasad also. Before that. This,
Yes.
27th January and 19th February. And then thereafter. For that.
Justice, one bench held that there was no necessity to direct exchange of affidavits.
That was a detailed order because we have not asked for, my lord. Last circuit and before last circuit I had short for, but the court said.
So we'll add a word positively.
My lord, positively.
Positively, positively.
According to the response, are directed to file their affidavit of opposition within 4 days from date.
Within 3 weeks. They didn't say 4 weeks. Never said 4 weeks.
Fortnight. Within 4
3
weeks.
weeks.
Fortnight. Within a fortnight from date.
No.
Positively.
Right.
Reply if any.
It shall be
Within
filed
1 week thereafter. Negatively. Yes. Negatively don't. Next step. Unexpectedly ডাকুন একটু বলে দিন। আচ্ছা জিজ্ঞেস না তো। বলে দিয়েছি অর্ডারে বলে দিয়েছি। Will be listed in the next segment. Before the next segment. একটু রসগোল্লা খান আপনি বুঝতে পারছেন নাকি? এবার আপনি ভ্যারাইটি আনুন, একটু পান্তে ফান্তে অন্য কিছু খান। এখানকার সুইট আছে, বুঝতে পারেন কি ভালো লাগে। Takes times we'll put it after this. Affidavits have been exchanged. Although the affidavits have been exchanged and the matter is ready for hearing, due to paucity of time in the present circuit, let the matter stand adjourned and be listed before the next circuit. Next step. Stop hearing. Mr. Kumar, from Monday, we'll not put the hearings in the list unnecessarily because you will have to come and then we don't take up. If there is any short matter among these, you can indicate to us today. Otherwise, we'll rise and take up the single bench till 2. We are calling for some time because all the advocates are not here. I mean, go on calling for some time. Yes. We're just making these not today. File the term. Not today, na.
Next circuit.
এটা কিছু অর্ডার প্লে করতে কিছু অর্ডার রেকর্ড করতে হবে না, তুমি ডাকো না, বুঝিয়ে দেবো। রাত্রিবেলা 10:30 11টা একবার বাড়িতে যাবেন, আমি বুঝিয়ে দেবো।
Item 10, shall we take 2024? Item 11, we have maybe 5 or something before.
Item 11, I have to respond. Criminal application.
No, not. I mean, we will not put it from the in the list from Monday. The hearing matters will not put in the list.
Well, shall we skip to 24?
Yes, sir. ये के देखे ना, अंदर के देखे. Utesh, we are not taking up any hearing matters, sir.
7 feet you are there with the ordinance from.
Which matter?
That makes it.
Take that.
That's why this time I'm not even trying to open.
I understand. So we are not taking. We'll sit singly after. Justice Das will sit right now. So you can do some matters and come back for me after 15 minutes. I'll sit after 15 minutes.
Yes.
Any missing article?
43, yes, what? Why?
Or if an application for allotting a shelter report being delayed and refused by the administration. Some issues with that.
Can't give any preference. Why? Others are also urgent. No, what did you want? What was refused? What was refused?
Our Honorable LG has ordered a shelter to provide me. The administration is refusing by several reasons.
Where are you residing now?
Now I am the shelter of one of my known details.
Item 43.
Yes.
Well, item 42.
That is
On Monday, it will appear at the top. Monday at the top. Inform the other side also.
government is going to appear. I don't know who will be.
Inform.
No, I supplied the copy.
No. We are putting it at the top. So either inform Mr. Sivabalan or Mr. Rakesh Kumar. Inform either Mr. Rakesh Kumar or Mr. Sivabalan that this will be taken up at the top on Monday. So that they'll make arrangements. No. It's not sure. Put is like any other person. You just tell Mr. Rakesh Kumar or Mr. Sivabalan that this will be taken up at the top on Monday. Thanks.
Item number 1, PRM NDPS 5 of 2026.
Your Lordship, I am appearing for the petitioner in this matter.
Yes.
For the respondent. Your Lordship, the FIR in this matter was registered on the 12th of October 2025. Your Lordship, the section laid down in the FIR was 22 subclause C. My Lord, relating to commercial quantity and the punishment there. Thereafter, and in the FIR, my Lord, I was not a named accused. Thereafter, police in another jurisdiction conducts a raid based on their information. And I am a driver, my Lord. I was driving the car, and the passenger in my car, 2 kgs of methamphetamine is recovered. Allegedly from the seizure. My Lord, I must seek your Lordship's attention to the seizure list. The seizure that has been done from me. My Lord, the seizure shows clearly it's not in my Lord, it's in the charge sheet. If I may place the charge sheet or the copy that has been supplied to the so, the next page itself is the seizure list, my Lord.
Yes.
My Lord, the petitioner is so herald. At the bottom 2-3 columns will find, my Lord, will find that the item seized from the petitioner is an Infinix Model 4 and a Ford style car, freestyle Ford car. There is no seizure of any psychotropic contraband material as in the Schedule 1 of the Act. Nothing has been seized from me. Yet I have completed a custody of 196 days, my Lord, as of today. My Lord, I have no past antecedents. There is no recovery from me. And as such, the rigors of section 37, which is based on the conscious recovery of the material, does not apply on me. My Lord, the charge sheet in this matter was completed on the 6th of November 2025. And since then, my Lord, the trial is pending. There are about 29 witnesses. No co-accused statement against me, my Lord. All the witnesses in the charge sheet are either the police or the independent witnesses of the police, madam. There is no chance of hampering or tampering with the witnesses or the evidences on record, madam. I may be granted bail, madam.
Yes, Mr.
First accused Suresh Kumar, the meth was recovered from him at Southern. During investigation, it was found there is a huge racket. The police party reached to the northern medium Andaman, that is Rangat area, and information was received that one car is coming with methamphetamine drugs. Then when he was stopped or she, this petitioner was driving that car. One passenger, that is different, the Caesar memo, he was sitting inside the car. And that was recovered. We cannot say it was not recovered because Caesar memo is speaking about that passenger. But it was seized from the car. the car belongs to the father of this petition. First, prior is stronger, and there is a specific bar under section 37 because more than 2 kg of methamphetamine was reached. Section 29 is there, total 3 accused person, and we come to the section 37.
NDPS.
May I read?
You are reading?
Section 37 of the
Yes. Let us
First.
see. Yes.
The offense cognizable, non-bailable, then every offense punishable under Act shall be cognizable. B. No person accused of an offense punishable for offences under section 19 or section 24 or section 27A. Here 22C is the attractive option. And kindly this part, kindly see this part. And also for offense involving commercial quantity shall be released on bail on his own one and unless first the public prosecutor has to give an opportunity to oppose the application for such release. 2. Roman 2. Where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. So, what is the reasonable grounds, Lord? We have already established the strong prima facie
So
evidence.
neither 19, not 24, not 27 against him.
Then next part, Lordship, can you see? Next part. And also, Lordship B, and also for offense involving commercial quantity. It is also applicable. Commercial quantity also include.
How is he connected? Only from his car, his father's car, he was driving.
Lordship. He was driving not because it was transporting for selling in different places by these two accused persons, including the petitioner. Suppose, Lordship, the car is not belongs to the father of the petitioner. We have no case.
Car belongs to the father.
Father of the petitioner. It is registered in the name of the father.
Son is driving the car. That does not necessarily mean that the
No,
son was involved.
Possession, different type of possession.
If I may qualify
To
this point,
pattern,
For possession, yes, personal, not maybe not on the person,
Lordship.
maybe in his, but it has to be within his control. Passenger sitting behind was carrying it. Might not have
There
been.
is not a commercial passenger.
Was the passenger known to him also?
No, see,
no, there is no
Lordship, it was a private car. Suppose it was a commercial use that one passenger carrying a meth and
I carry my friend is carrying meth. So
it's a local village, my lord, a very small community of Karen
no,
community.
don't give a running commentary. The prosecutor is
respectful submission is the petitioner hearing and the passenger who cannot say that the passenger was carried in a commercial vehicle in consideration of the rent amount for that vehicle, he has no knowledge. You have the knowledge, conscious knowledge. Yes, my car with one person, male person, carrying more than 2 kg methamphetamine, of course it was a conscious position. Then it was recovered. So that is my respect to humble submission. There is a bar under section 37 because commercial quantity. Because more than 50 grams is a commercial. Here more than 2 kg.
Learned counsel for the petitioner contends that there is no direct nexus between the petitioner and the alleged offense, even as per the disclosures in the FIR. By placing reliance on the seizure list, comma, a copy of which is handed over to the court by learned counsel for the petitioner, comma, it is submitted that the only seizure effected from the petitioner was a mobile phone and not any contraband material. Next para, that apart, comma, it is submitted that that none of the co-accused persons named the petitioner to be as being involved in the crime. Further, comma, it is submitted that the petitioner is languishing in custody for about 196 days and has no past antecedents of crime. Out of the 29 witnesses cited by the prosecution, comma, none have been examined as yet. Next para, the petitioner's alleged involvement was only restricted to driving the car from which the offending material was recovered. please, from which the offending material was recovered, full stop. However, comma, it is pointed out that that even as per the prosecution case, comma, the material was recovered not from the person of the petitioner, but from the passenger who was sitting in the car. Full stop. Hence, comma, there is no direct involvement between the petitioner and the allegations, alleged offense. Full stop. Next para. Learned counsel, the learned public prosecutor, comma, while opposing the bail, comma, submits that the petitioner was driving the car in which the contraband material was recovered, and, comma, as such, comma, it can be said that the petitioner was in constructive possession of the seized material. So that apart, comma, the car which was being driven was a private car and not a commercial vehicle, and belongs to the father of the petitioner. So thus, comma, it is submitted that the involvement and knowledge of the petitioner in the crime cannot be ruled out. Next para, learned counsel places reliance on the second limb of section 37 within bracket small b of the Narcotic Drugs and Psychotropic Substances Act, 1985, and argues that the rigors of the said provision in respect of bail also apply to offences involving commercial quantity, comma, thus validating the involvement, the allegation of involvement of the petitioner in the offence. Next para, from a perusal of the seizure list, comma, it is seen that the material allegedly recovered from the petitioner was a mobile phone. Full stop. None of the contraband materials were recovered from the person of the petitioner. Full stop. The alleged involvement of the petitioner was only in driving the car. Full stop. Ex facie, comma, there is no direct involvement of the petitioner. Full stop. Although the expression double inverted possession double inverted clause in respect of such offences may not be limited to recovery from the person of the accused, but at least it has to be established prima facie, comma, for the rigors of section 37 to apply, comma, that the petitioner is in some manner in control and in possession of the seized material. Full stop. Merely driving a car does not entail such a conclusion. Full stop. Next para. That apart, comma, since no past antecedents of crime of the petitioner has been pointed out, comma, and the petitioner is already in custody for about 196 days, whereas the charge sheet was filed on November 6, 2025, after conclusion of investigation, and out of the 29 witnesses, none has yet been examined. Full stop. Next para. On the other hand, comma, section 37 within bracket 1 within bracket small b of the 1985 Act cannot be read in isolation from the offences mentioned in the said Act. Full stop. In view of the above, comma, and taking into consideration that the petitioner had no past antecedents and that the public prosecution has been heard, comma, the court is satisfied that there are reasonable grounds for believing that the petitioner is not guilty of the offence and is not likely to commit any offence while on bail. Full stop. Next para. Apart from the rigors of section 37 not being prima facie applicable to the petitioner, comma, even if it is so assumed to apply, comma, the benefit of clause small ii within bracket of section 37 within bracket 1 within bracket small b are attracted in the present case. Whose sub next para. Accordingly, CRM within bracket NDPS 5 of 2026 is allowed, comma, thereby granting bail to the petitioner on condition that the petitioner furnishes bail of rupees 10,000 with 2 sureties of like amount each, comma, one of whom must be local. Full stop. The petitioner shall not leave the territorial jurisdiction of the trial court during the entire period of trial and shall attend on each and every date of trial, as well as report to the, which is the police station?
It's Chatham.
Pardon?
Chatham police station.
Chatham.
Police
Chatham.
station Chatham.
Commissioner is a resident of Mayadanda.
Oh, shall not leave the territorial jurisdiction of trial. That is in North and Middle Andaman. That shall not leave the territorial jurisdiction of the trial court. Shall not leave the territorial jurisdiction of the North and Middle Andaman district, except for the purpose of attending the trial, comma, without the prior leave of the jurisdictional court. Next para, that apart, comma, the petitioner shall report once every fortnight to the Mayabandar. There is a PS Mayabandar.
Yes.
To the Mayabandar police station. First up, next para, the petitioner shall also not make any attempt to contact the witnesses and or intimidate and or induce the witnesses and stroke or tamper with the evidence in any manner whatsoever throughout the period of trial. Thank you. Thank you. If you can, please just give a photocopy of the charge sheet to the satisfaction of which court?
To the satisfaction of CJM court Portland.
CJM court.
I will hand it over right. I'm going to get a copy.
When he hands over, keep it in the right. Thank you. Yes.
Item number 2, PRM 11 of 2026.
Yes.
I have filed a CRL in respect of a sentence under section 138 of the Act, in which CRM and CRL also filed. Your Lordship, I don't want to contest the case on merit, but I want to solve my case under the guidelines framed by Supreme Court of India in Sanjabi versus Vinay Kishore Borkar.
Have you got a copy of this?
I
So now what is your prayer?
bail will be granted and suspension of the sentence will be just.
You are for the state?
I'm for the complaint of the.
Give a copy to the to Mr. Kormokar and I'll take it up on Monday. Since no copy of the application has been served on the state, comma, we request Mr. Kormokar, comma, learned public prosecutor, comma, who is present in court, comma, to accept copy on behalf of the state and direct the state to regularize the appointment of Mr. Kormokar in the present matter. Who's sir? Have you handed over?
No,
I
have received.
It is recorded that pursuant to the above, comma, a copy of the application is handed over here and now to Mr. Kormokar. Kushab, let them list the matter on April 27, 2026.
Your Lordship, I have to surrender on 27.
You have a
Surrender to the Lord on 27 itself.
you should have given a copy to the state earlier. Now he takes some time to take instruction. What can be done? Surrender to which police station? You reside in that area.
Yeah.
Surrender.
Yes.
But if you surrender, then
To the Lord Court. It is a confusion matter.
but this is a bail application.
The bail application.
You surrender, that will be subject to the outcome of this. It's a bail application, not anticipated bail.
And CI and also the
Add a line.
extent operation of contest.
Add a line. The petitioner shall surrender before the jurisdictional court.
MF2.
Pardon?
MF2 for
On Monday 27, 2026, comma, as per scheduled. So, however, comma, such surrender will be subject to the outcome of the present application. Petitioner need not be personally present in court. You be present and move the matter. Yes. Madam, yes.
Item number 3. Is the important project 2. That 3 and 4.
But here we are going to petitioner. This matter was listed in this circuit itself. So this has to be placed.
That's why I want.
Because there is a application.
So why is it coming here?
Because
They file like cat.
Automatically it has come. Main matter is still listed before the other two.
Main matter occupants already.
Already
Next circuit.
next circuit.
So if they want an CAN application has been filed.
For the court.
Learned counsel for the parties submit that the matter was already heard by the other learned single judge sitting in the present circuit. So accordingly, let the matter be placed in the list of the said bench.
Yes.
Monday, you go there on Monday. Before action is used.
Item number
This will
5.
make it plural. Matters.
Let's-
Matters.
let's-
Three, four together.
Let's.
Item number 5, I'm waiting for time for filing.
Reply.
Against this, 5.
You are appealing? Yes.
Correspondent.
Well, on the pair of the appellants, comma, the time for filing affidavit in reply is extended for a fortnight from date. Push up, let the matter be listed before the next hearing.
Okay.
Item number 6. Here I make up front 26.
You have given a notice to the state? Mr. Kormukar was appearing on that. And he paid for 10. He was here. We are passing it over. Passing it over, please inform Mr. Kormukar, and whenever both of you come, we'll take it up. Pass over, will you? After the electricity matters, we'll call this.
Item number 7. CPN 28 of 26.
Down. Right. Since the contempt application arises out of an order passed by Pompa Sarkar J, comma, the registry is directed to place the application before the said bench.
Item number 8. WP 102 of 26.
I am appearing at this.
It is for grant or
Sorry, grant of?
it is below.
He's already having two characters.
Lordship, this is a third round of litigation. Let me place my case on. Lordship, firstly, I have applied for electricity. After the stupidity period when the department was not giving electricity, I filed a writ application before this honorable court. The order is at page number 15, Lordship. Wherein Honorable Justice Sudandra Bhattacharya was pleased to grant the registration that my application may be considered an appropriate order will pass. After that also they have not given me electricity. I came before the honorable court in the second round of litigation. Lordship, page number 70 is 386 of 2025, wherein the honorable justice was pleased to direct that they have stated that before the court that I am having two electricity connections, one in my father's house and one in an shelter, tsunami shelter. I have stated before this court that the meter of the tsunami shelter may be transferred. As said, the honorable court, honorable justice Hiranmay Bhattacharya was pleased to grant me the order. The page number worship 1780, the appropriate portion worship. The petitioner claims to be occupation of the government revenue land, survey number 2 Western 2005 Valley Card. At the same plot, constructing resident dwelling house, the petitioner claims to be applied for electricity connection. The grievances petitioner is stated that respondent authorities have not supplied electricity to the petitioner at the same property. Learned advocate appearing for the respondent authority service that the petitioner is having to electricity connection.
I've read it.
Yes. And after that, this order was intimated, and it is It is at page number 21 also. That according to that.
You have filed an application for transfer.
Yes, Lord. I filed it
They are not
transfer.
dealing with that.
They are not dealing, they are sitting tight with the matter, and then in the last circuit, they have given the affidavit of opposition.
What is the saying that?
It is very.
That you have two connections.
Yes.
The father's connection is in your father's
No,
name.
Lordship. Lordship, page number 11, point number 11. Page number 11, point number 11, existing connection on revenue land father's name. That the other electric connection bearing consumer account number that code 2073 is installed on a building situated revenue land registered in the name of my petitioner father.
No, but the electricity connection is in your name. It's
Yes.
in a different house.
It is a different house. It is
No,
my
Lord.
father's house.
Same
Lordship.
house.
And moreover, I have filed an application that an meter in the shelter, tsunami shelter, may be given to me that. And when this was propped up before the Honorable, they have said that it can be given. But after that, they saying since it is tsunami shelter in front. In one line, they are stating that the
So
meter is in my name.
tsunami shelter is a different prospect altogether.
It is
Tsunami
belongs
shelter,
to government.
yes, tsunami shelter not only belongs to government, you are residing there. Now, if this father's house registered in the name of your father, land is registered in the name of your father is not a material consideration. In the same house, you have another meter in your name. So
Okay.
registered in house is registered in whoever's name.
Lordship.
I may be a tenant. I may have an independent connection. House is registered in the name of landlord, but I cannot have another connection.
Lordship, I was having a land, survey number 12.
Whatever.
In the year 2004,
If the house is
tsunami
the same, tsunami shelter, you don't have a matter of, as a matter of right, you cannot transfer that to your name. It's not a right. Tsunami shelter was for a specific purpose. At that juncture, you were in the tsunami shelter, you had got the connection. But now you are not residing there, so you should surrender that. But no, we are not giving liberty. Now see, you are not entitled to a different connection in your own name. Even if it's transferred from the tsunami shelter to your residence, the effect will be the same. You will be given two connections in the same house. That will
different.
Where is the pleading that it's a different house?
It is enclosed land. Lordship.
Have you filed a reply to opposition? No.
No, Lordship, it is an enclosed land. And for enclosed land, for grant of electricity, we have come before the Honorable purpose.
Where have you stated? Have you stated anywhere that it's
Yes,
a different house?
It is there, Lordship.
Para 7 in their opposition, they have stated that during field inspection, it was observed that small dwelling house structure has been constructed at the site where shifting is sought, which is recorded as enclosed government revenue land under survey number 12.
Yes, sir. I am residing there. Lordship. I don't have.
He is not residing there.
You have a connection in your father's name.
It is.
You want the connection to be given there only.
No, Lordship. In this house, I am not having. They are talking in some other landed property, which is a revenue land. This land is an enforcement land where I am seeking electricity connection. And since this is an enforcement land, they are not giving electricity.
So their ground is that since it's encroachment, that's why.
Yes.
No, that is not the ground.
Yes, please see para 7 and 8 of your opposition. That is your ground. You have stated they are wanting this connection to a proper dwelling house, which is recorded as enclosed government revenue land. Para 8, you say you are not the landowning authority and you are not empowered to regularize encroachments. Shifting of a meter is merely an administrative technical, does not confer validity. So this is contradictory. You will not, obviously contradictory. You give his answer in your opposition.
Let me file a short supplement.
No, give the connection.
Lordship, my objection that the recorded Lordship is already having two connectors.
But you have not stated that. There is no pleading to that way.
Lordship, in my report I am having Lordship.
You have stated, para 9, that it is respectfully submitted that a person already possessing a
Lordship,
legitimate
kindly.
in his name cannot demand another.
See the photograph.
Yeah, there has to be some.
This is the encroachment.
No, there has to be some pleading. We don't know. We can't look into the photograph. And let us see his application. I mean, and he has stated in his application actually that. This is 2073 and father's one is 207. No, the same.
But it is recorded in his. He has taken the meter in both the in the
No,
tsunami
one
shelter.
second. In 11, clause 11 at page 11 of their this thing, this position. This is a part of your application. Yes, this is your application. Page 10 of their opposition. Clause 11 you showed.
No, it is there. It is there. Page number 11, clause 11, they have, in their affidavit operation, they have filed this document.
Oh, this is the assistant engineers.
Yes, yes, yes.
No, it says that the other electric meter bearing consumer such and such is installed on a building situated on a revenue land registered in the name of the petitioner's father.
That's it.
You haven't annexed your application? But this is the application, page 21. It's
That
not
is allotted land.
Yes, Lordship. Yes,
This
Lordship. This is my application.
allotted by the administration.
Lordship, this is the application. Page number
He
21.
is staying with his father only.
Lordship, there is
No,
No, he's staying with his father or not, you are not entitled to look into that. You are not the authority to do that. See, clause 9 of page 11 of your opposition,
That's it.
that one of the connections, namely such and such, installed at Ongi Tikre, permanent shelter. You say this is non-transferable. This is that tsunami shelter.
Yes, Lord.
So you cannot blow hot and cold in the same.
Exactly, Lord. Exactly.
Because before the previous bench, you said that it cannot be.
Now, the judge said this is a department direction.
The court gave liberty to transfer, and then you are denying that. You did not point this out before Justice Hiranuma Bhattacharya. It's non-transferable. If it's non-transferable, then give him an independent connection. His application is already there.
He has to apply a first lordship. We have already rejected his application.
Some 3 times Lordship. Kindly the order given Lordship. Some 3
He
times.
may apply a first lordship online.
Why should he? We will set aside this rejection.
He has not prayed for that.
I already prayed Lordship. I prayed page number 11 Lordship.
You are residing at 12
Yes, Lord. Survey number 12.
Kalinagar village, Hadwe,
Yes.
and the existing connection is
He
where?
only take the Lordship. Which is.
No, that is the shelter connection.
Shelter.
No, father's residence. Where is that?
Father's residence is at.
No,
It is also at the same place, Lordship, Kalinagar, but it is in a Lordship.
you have stated anywhere.
Revenue land, Lordship, revenue land. It is a revenue land in the name of my father. Yes, assistant property law.
Achha. And this is a enclosed.
Exactly. Survey number 12.
No, but since previously your application for electricity connection was rejected, and the court gave you liberty to file a transfer application,
Lordship, it was not rejected.
not being heard out.
Not been heard out. Court give me
It was rejected.
No, Lordship. The order may be seen.
When first strict reason he has filed,
No, first order directed them to consider. Let us
Yes.
see the second order.
Second order, Lordship, page number.
for transfer, he has to
So
apply.
page number 19, Lordship. Page number 19, Lordship. The grievances.
No, they only said that you are not entitled. You did not say that you have rejected.
Yes.
No, as stated. See, please come to page 19. Page
But-
19, second paragraph. You had submitted that the petitioner is having 2 electricity connection, therefore not entitled to supply of electricity. In your presence, the court directed transfer. Now you take you take a stand which is contrary to the direction of the court. This amounts to contempt of court actually. You cannot say that. This 12 Kalinagar village stands in whose name?
Is an encroachment land. I'm encroaching the same.
The father's land is also encroachment.
No, that is in the name of my father.
Name of father.
That is the ancestor property.
No. Acha, yes. Father's, you have not mentioned the father's other connection. You have said in para 9 of your opposition, person already possessing a legitimate electricity connection cannot demand another connection. It has to be in the same house. You have not stated in the same house.
Both houses are 3 kilometers far away. My encroachment line and
No, no, you allow his, bring the electricity subject to his complying the formalities on his application, which is already there. Stephen, the present application arises at the behest of the petitioner, comma, who resides under survey number 12 at Kalinagar village, comma, Hut Bay, comma, South Andaman, which is admittedly an encroached land, comma, where the petitioner sought an electricity connection. First up, in a previous round of litigation, comma, since the said application was not being disposed of, comma, a coordinate bench, comma, vide order dated January 29, 2025, passed in WPA 23 of 2025, comma, had directed the respondent authorities to decide on the application for such electricity connection made by the petitioner and for the assistant engineer, comma, respond number 3 therein, comma, to communicate the decision to the petitioner thereafter. Question next para. Subsequently, comma, such connection still not being given, comma, the petitioner had to approach this court again by moving a writ petition bearing WPA number 386 of 2025, which was disposed of on December 15, 2025 by another coordinate bench. Question before the said bench, comma, the respondent authorities took a stand that since the petitioner already has another electricity connection in his own name, comma, therefore he is not entitled to any supply of electricity at the premises in question. Question next para. Upon such submission being recorded, comma, the learned single judge gave liberty to the petitioner to file an appropriate application seeking transfer of the electricity connection at the tsunami shelter of the petitioner at Ongie, ONGIE, Tikre, TIKREY, comma, permanent shelter number B2-12/A, to his present dwelling house. First up, if such application was made, comma, the respondent authorities were directed to consider and dispose of the same in accordance with law by passing a reasoned order. First up, next para. However, comma, even thereafter, comma, the respondent authorities refused to grant such transfer inter alia on the ground that another electricity meter bearing consumer account number Z4/2073 is installed on a building situated on revenue land registered in the name of the petitioner's father. Full stop. Next para. At the time of hearing, comma, learned counsel for the petitioner submits that the land registered in the name of the petitioner's father is different from the dwelling house of the petitioner where the electricity connection has been sought. Push up next para. However, comma, learned counsel appearing for the respondent authorities contends that the petitioner is already enjoying an electricity connection at the self-same dwelling house, comma, standing in the name of his father. Push up next para. However, comma, the court does not find within the four corners of the affidavit in opposition used by the respondent authorities any mention of the petitioner's dwelling house being the same as that of his father, comma, where another electricity connection is already existing in the name of the petitioner. Push up rather, comma, in the affidavit in opposition, comma, the primary ground of refusal by the respondents was that the petitioner is that the dwelling structure, that our dwelling structure has been constructed at the site where shifting is sought, which is recorded as encroached government revenue land under survey number 12. Full stop. Next para. Further, comma, it is contended in the opposition that the respondent department is not the landowning authority and is not empowered to regularize encroachments. Full stop. Next para. However, comma, in the same breath, it has been stated that shifting of a meter is merely an administrative and technical process and does not confer, validate or recognize any right, title or interest over the land in question, which are patently self-contradictory pleas, PLEAS. Next para. Thus, no whisper was raised by the respondents at any point of time, either before the previous courts taking up the matter or in their affidavit in opposition, to the effect that the father's house of the petitioner, where another electricity connection is standing in the name of the petitioner, is the same as the dwelling house of the petitioner, where the connection has now been sought. Thus, the respondent authorities cannot go beyond such pleadings at this stage. Next para. We also find, the court also finds that the order directing the granting liberty to the petitioner to file a transfer application and directing the respondent authority to consider the same, dated December 15, 2025, was passed in the presence of the learned advocate for the respondents. However, even at that juncture, no demur, DEMUR, was raised by the respondents on the ground that the house of the petitioner's father and the petitioner's dwelling house, where the transfer is sought, are identical. Next para. Even otherwise, as admitted by the respondents in their own affidavit in opposition, mere grant of electricity connection does not create any special equity or right or validate the character of possession of the occupier. Rather, under section 43 of the Electricity Act, it is the mandate of law, which is also read into the right to life under Article 21 of the Constitution of India, to have basic amenities such as electricity. Hence, the court does not find anything on the record to indicate that the dwelling house of the petitioner where the connection is sought is the self-same house where the petitioner is enjoying another electricity. The mere fact that two electricity meters at two electricity connections exist at two different places, even in the same name of the same person, creates any bar in the petitioner having such second connection. Accordingly, since the respondents have now taken a plea in their opposition that the connection at the tsunami shelter is non-transferable, and there is nothing on record to show that the initial application of the petitioner dated January 29, 2025 for a fresh electricity connection was rejected at any point of time, WPA, what is the number? WPA number 102 of 2026 is disposed of by directing respondent number 3 to immediately grant electricity connection, fresh electricity connection to the petitioner at his dwelling house at 12, what is the full address? Kalinagar village, Hut Bay, South Andaman, in terms of the application, subject to the petitioner complying with due formalities. It is expected that such connection will be given within a fortnight from date and from compliance of formalities by the petitioner, whichever is later. No rest to cause service. Next.
Item number 9, WPA 110 of 2026.
My Lord, Mr. Prakash Mij appears for this matter petitioner. He has instructed me to seek let the matter be given to the next circuit.
On the prayer of the petitioner, the matter is adjourned till the next circuit.
Item 10, WPA 164 of 2026.
If I could not get instruction, can it be on
For
the
the
list?
for grant of electricity.
You will move the matter, or you are asking for time in this also?
No,
If you ask
so
for-
as for the petitioner, service is complete.
Just not today.
Good. On the pair of the respondents, the matter is adjourned for the day.
Item number 11, WPA 170 of 2026.
None appears for the parties at the time of call. Let the matter stand adjourned till the next survey.
Item 12, WPA 174 of 2026.
For the repetition. His application is pending. Application is on page number 11.
The grievance of the petitioner is that the petitioner's application for fresh electricity connection is pending. Next para, upon hearing learned counsel for the parties, WPA 174 of 2026 is disposed of by directing assistant engineer should have been made a party. Superintending engineer is the, yes, he is a party. Two. Directing the respondent number 2, the assistant engineer, Shahid Dweep, electricity department, to dispose of the said application of the petitioner for electricity connection within a fortnight from date and communicate the outcome to the petitioner within a week thereafter. Next para, in the event the petitioner is found otherwise eligible in law to get such connection, the respondent number 2 shall ensure that such connection is given within a fortnight from compliance of all formalities in that regard by the petitioner. No rest to cause satisfied. Thank you.
Okay.
Thank you.
Item number 13, WPA 177 of 2026.
Madam, the service has not been effected to the private.
Learned counsel for next second. Learned counsel for the petitioner submits that service has not yet been effected on the respondents and on the private respondents and seeks accommodation till the next circuit. Private respondents.
Official.
Full stop. Accordingly, let the matter stand adjourned till the next circuit. You give your names on a slip.
Item number 14.
14 and 15, same as item number 12 for the repetitions. Service is complete.
No, item number same as item number 12.
That's it.
12 what order did I pass?
Just now, your lordship, for considering item number 10.
Oh, that consideration.
10.
Same as 12. Thank you. Same one. About password.
Pass over matter. Theorem 8 of 126.
Stephen, the repetition numbers will be different. Item কত এটা?
6 loss.
Awesome.
After that.
This. But it's also dated in some February 2020. While enlarging the period, this petition was directed.
You're too tall for the microphone. Either you shout or take the microphone top. Yes.
While enlarging the accused person on certain conditions were one of such conditions.
Which page?
It's appearing on page number 9 also.
Right.
One of the condition is that the accused person to meet the SHO Bharatan each and every day except Sunday.
Page 9.
Page 9 also. Plan application.
Oh,
Plan
yes, right. My mistake.
By the way of this grant application, I am seeking a temporary modification of that petition because lordship, the mother of the petitioner is residing in Tamil Nadu and due to
What is the offense?
lordship, it's a matter under section 103 of PNF. Due to certain events, the mother of the petitioner has to be taken.
Tamil Nadu will be risky.
Lordship.
Leaving you to go to Tamil Nadu may be risky. Permitting you to go to Tamil Nadu may be difficult.
Lordship,
That is,
I am not seeking,
if you, yes.
I am not seeking the modification of that. I am seeking very temporary modification for 30 days, minimum of 30 days, so that I can proceed to Tamil Nadu.
30 days you can proceed to wherever you like in the world. 30 days is more than enough. You can go around the world in 30 days nowadays.
I have proceeded on this one.
Who else is there in the family?
There's only mother, Lordship. There's no father.
No siblings.
No siblings, sir.
Have you stated anywhere? In these matters, you should state it.
Lordship. I am stated
Paragraph
Paragraph
5, 6 onwards, the nature of injury.
and I stated it in paragraph 8, Lordship.
No other responsible family. Who are the responsible family members?
Lordship, like immediate family members are not there, Lordship. The petitioner and his ailing mother are
Other family members are there, are illiterate and unable to manage medical procedure.
district. Lordship, kindly appreciate. I have a closing.
You have not said dictionary, you have said illiterate and unable to manage medical procedure.
Lordship,
Illiterate persons can manage medical procedures. They have to.
Lordship, the difficulty is the treatment has to be taken at Bangalore, Lordship. So mother has to be taken from Tamil Nadu to Bangalore. They are resident of Krishnagiri district, which is nearby.
So
to
therefore now you are modifying your initial
Bangalore.
prayer.
Seeking for temporary modification.
No, you have stated here Bangalore.
Lordship, after coming back to Kotware, I will continue with the same.
No, who will ensure that you will come back? If
Not
you
the
jump the bail, then it's very difficult. Nature of offense is serious.
Lordship.
Yes, what do you say, Mr. Public Prosecutor? He's the other. No, he's the one giving the contract.
No, he is also contractor, came from Madurai.
We refused him bail.
No.
We granted him bail.
Let's see, kindly come to the page number 10 of order dated 10th February 2020.
Yes, we are there. I am there.
Third paragraph.
Third paragraph, yes.
Petitioner may find bail or rupees 50,000 possibility of rupees 30,000 each out of the.
Oh, yes, I remember now. I relaxed the bail once a week, and he can renew his prayer before the jurisdiction.
Jurisdictional. So liberty was already granted. Kindly see the order specific direction. Liberty already given.
You cannot leave the jurisdiction of the Baratang police station. In the other matter, I passed a similar order. I'm just telling you because you are not there. Because you have been given the liberty to leave with permission of the district and session judge Port Blair. That leave is there. I'll reiterate that. But if you have to report each and every day to the police station Baratang, it may be difficult. So, but you are asking for 30 days, it's difficult. Everything has to be arranged. You can go there. You have to come back within 1 week. I can at the best make it, you have to report to the Baratang police station once a week. That will enable you to ask from the jurisdictional court to leave, to take permission for a week. I'll give you that liberty. I'll not give you 30 days, but I'll arrange the matters so that you can pay for a week's time. The present petitioner.
Small in terms of yesterday's order, at least in this condition, we will relax that the petitioner to meet SHO each and every. That condition.
No, that is what I'm doing. I'll do that precisely that.
Lordship.
I'll modify that to the extent that you have to meet only once a week.
Lordship.
So that you can ask for that prayer. Give the reason also. The petitioner seeks modification of one of the conditions of bail as imposed with the order dated February 10, 2026 in CRN 8 of 2026 to the effect that the petitioner was directed to meet the station house officer, PS Baratang on each and every date excepting Sunday, which is prohibitive in nature, since the petitioner, due to the exigent reason of the physical ailment of his mother, has to leave the territorial jurisdiction of the Baratang police station in order to have his mother treated by taking her from his native place at Tamil Nadu to Bangalore in Karnataka. Next para, the learned public prosecutor opposes the prayer for bail, particularly on the ground of the gravity of the offence. Next para, however, upon hearing parties and balancing the convenience of the petitioner with the nature and gravity of the crime against him, the court is of the opinion that a limited modification of the condition of bail may be granted by relaxing the necessity to meet the station house officer, PS Baratang, each and every day. Instead, if the petitioner is directed to meet the SHO once a week, the petitioner will be at liberty to seek permission to leave the territorial jurisdiction of the Baratan police station from the jurisdictional court, which liberty has already been incorporated in the conditions of bail. Next para, accordingly, CRAN 1 of 2026 is allowed, thereby modifying the condition of bail imposed vide order dated February 10, 2026 in CRN 8 of 2026 to the limited extent that the petitioner shall meet the station house officer, PS Baratan once every week instead of on each and every date. It is further reiterated that the petitioner will be at liberty to avail of the provision made in the order of bail by seeking permission from the jurisdictional court in the event the petitioner has exigency to leave the territorial jurisdiction of the Baratan police station. This one, urgent sector. Right. Top.
Item number 16, review 6 of 1226.
But before the original proceeding, I was not defined. Before the
That leave your file.
leave, I have filed another application of second. Application under section 5.
Leave এখানে appear করছে না কেন লিস্টে? আজকে today if I give copies to them, I'll direct you. Yes, sir. We'll keep it on Monday so that those applications can appear with this. Learned counsel for the review applicant submits that applications for condolation of delay in filing the review application as well as leave to file the same have been submitted only today. Next para. Accordingly, let the matter be listed next on April 27, 2026, along with the connected application. Since the court is informed that copies of those applications have already been served on the respondents, no further direction is being passed in that regard.
Same meeting.
You have also got a copy.
Item 17, WPA 152 of 1226.
Yes.
My lord, I have concluded my argument. My lord, I applied for a consent to operate a crusher,
That's
small crusher unit. Now, my lord, before I could start it, because that has not been given, my lord, a stay order followed by a seizure order was passed without giving any opportunity.
What have you challenged here?
The stay order and the
You have challenged
seizure
both the
order,
orders.
both the orders. And my lord, I have argued that without giving an opportunity of hearing, it's a clear case of violation of principle of natural justice. And it was fallen from the court after going through the statute that even the authority did not have jurisdiction. So my lord has asked her to satisfy the court whether the person who has issued this.
What is the statute? I mean, just show me again. I forgot.
My lord, can you
It's annexed somewhere.
my lord, can you come to page number 27 is the stay order.
If there were running a stone crusher unit without having the stone crusher unit without having the pollution control that pollution clearance certificate. For that reason, it was seized.
Which page?
Page 35 and 36.
Yes.
152, my lord. It was an absolute order, no further proceeding or any opportunity of hearing. Thereafter, here, my lord, at page 36, they affected seizure of my crusher units. And this was never served to me also.
Focus your attention. It was served because I think it was passed on 24th July 2025, and thereafter.
No, the first order was served. But before the seizure, there is no recording in the seizure order also.
6. Swami, he was served.
Name is there, he was never served, we have got.
Which page?
Page 36.
He's a order.
36 is
Last, you know, the syllabus copy too.
copy of this order after passing the Caesar order. Where is the right of hearing? I mean, he has to be heard. This is a penal order.
And my lord has asked, my lord, that was not my learned friend was fairly submitted. Now my lord has asked the jurisdiction of the Tahsildar because that was.
That is at page 27. This
No, my lord has asked the jurisdiction of the Tahsildar to issue the stay order and the
yes.
notice because under section 201, only in mining operation he has some jurisdiction.
201 of the
Land
CR.
revenue and land reform
Oh, अच्छा.
regulation.
जाओ तो इधर. Right, that. It's now in.
Yes, it is. But it was falling from the book.
Yes, Ms. Das, you had to satisfy on that also. This is neither a quarry nor a mine. You have right over quarries, mines, stones, etc. But the stone is boulders are brought and cast. A finished product is produced and
Clearance certificate. For that reason only, it was,
it appeals to reason that yes, they should require that.
yes.
But-
That is the mandatory requirement, my lord. They should possess the pollution control certificate for running a stone crushing.
But there must be some notification or something in that regard. That is why it was could not be heard out on the last day. You have to produce something to show that. But there is nothing to show that he was served the notice even before the first order. After passing the first order, he have sent the copy. He admits that. Mr. Vinay Kumar admits that the first order, he got a copy. But after the order was passed, he should have been given a hearing. Because see, at least two things are there, Ms. Das. First, he would be entitled to show that there is no provision for pollution control. Obviously, it appears to logic that there should be something.
My lord, there's a notification that the stone crusher unit is.
Should have been heard on those things. I mean, both these orders are with audio alternate part and set aside on that ground only, and clarify I have not gone into the merits and fresh hearing upon notice, and then the writ petition has been filed by the owner of a stone crusher unit. The petitioner alleges that by an order dated December 31, 2024, the Tehsildar, Sri Vijayapuram, directed the petitioner to immediately cease CEASE and desist from operating the stone crusher on the concerned land, as such operations were deemed illegal, until further notice or order, by a subsequent order dated July 24, 2025, the Tehsildar directed that the stone crusher unit shall be sealed, SEALED, forthwith. Next para, learned counsel submits that although a copy of the stay order dated December 31 was 2024 was served on the petitioner, after the same was passed, no prior notice of hearing or opportunity of representation was given to the petitioner before passing either of the orders. Next para, learned counsel appearing for the respondent authority submits that a pollution control certificate is necessary for running a stone crusher unit, in view of the obvious reason that the same creates environmental pollution. Next para, as such, it is contended that the Tehsildar was justified in passing both the orders upon attributing sufficient reasons for the same. Although the court finds from the first order dated December 31, 2024, that the Tehsildar was of the opinion that the petitioner does not possess the necessary pollution control certificate, comma, the Tehsildar ought to have granted a prior opportunity of hearing to the petitioner, at least in order for the petitioner to satisfy the Tehsildar as to whether he actually had such a certificate and or was at all operating the said unit, comma, the latter component of which the petitioner denies before this court. Full stop. Next para. Moreover, comma, the necessity of a pollution control certificate was also a bone of contention, comma, for which opportunity of hearing ought to have been given to the petitioner before passing even the stay order. Full stop. Next para. The subsequent seizure order imposes a penalty on the petitioner by sealing the stone crusher unit altogether. Full stop. Apart from the necessary consequences of the said unit possibly degenerating due to unuse, comma, the mere fact of sealing the same also pertains to the livelihood of the petitioner, even if he subsequently obtained a pollution control certificate. Pollution certificate. Full stop. Next para. In such view of the matter, comma, the court is of the opinion that the basic tenet of natural justice, that is audi alteram partem, was squarely violated in passing both the orders without granting any opportunity of hearing to the petitioner. Full stop. Hence, comma, WPA 152 of 2026 is allowed on contest, comma, thereby setting aside the stay order dated, the impugned stay order dated December 31, 2024 and the impugned seizure order dated July 24, 2025 passed by the respondent Tehsildar, and directing the respondent to consider the necessity of passing a stay order from that stage afresh upon giving adequate prior notice of hearing to the petitioner. Full stop. Next para. It is, comma, however, comma, made clear that the merits of the contentions of the parties have not been entered into at all, and it will be open to the respondent. Let's say there is respondent number 2. Respondent number 2. It will be open to the respondent number 2 to consider the matter afresh on its own merits without being influenced in any manner by any of the observations made above. Respondent number 2, the previous direction was also to the respondent, I've seen. No. It will be respondent number 2. No. By the point of jurisdiction, so it is further clarified that all questions, comma, including the point of jurisdiction stroke authority of the Tehsildar to pass such orders, are kept open for being urged before the Tehsildar. Thank you.
Item 18 on 306.
Here we have to respond to 3 and 4.
Here, this applicant has applied.
Mr. Kumar, you are applying for the 1 and 2.
Yes, yes. This is with regard to that pollution clearance. On 20th of January 2020, this petitioner has made an enter into a lease agreement with a party.
So it is January
2021.
Lease, yes.
Yes, lease and taken 1,000 square meter of land.
Fighter. Oh, sorry. Lease, yes, yes.
1,000 square meter of land, pay 10 lakh rupees.
1,000 square meter.
1,000.
1,000 square meter, 10 lakh rupees.
10 lakh rupees pay for the purpose of running the stone crusher unit. Now, my lord, on 24th of January 2022, you make an application before the Pollution Control Authority for obtaining consent to operate the stone crusher unit. Now, my lord, I will just place those documents first, my lord. My lord, just
first, let us hear the grievance, then we'll go back to that.
Now, my lord, when I applied, my lord, subsequently the Pollution Control Authority written a letter to the Revenue Authority, my lord, whereby asked for the details, the recommendation and all, along with the performer, asking them to fill up the performer and give it to them. the revenue authority issue after conducting inquiry on 18th of May 2020. Sorry, my lord, on 18th of April 2022, submitted a report before the Pollution Control Authority recommending the case of the petitioner and the status report. Now thereafter, my lord, this authority, the Pollution Control Authority, has not acted for near about 2 years, my lord. And subsequently, when my client was repeatedly approaching them, they asked to file an application through online. My client once again filed an application through online. They once again sought for certain clarification from the revenue authority. They have given the clarification. Now, my lord, subsequently, my lord, the respondent number 2. The Coastal Zone Authority, my lord, writes a letter whereby informed that the land falls within CRZ2, CRZ area. And on the basis of the same, the pollution control asked me to obtain clearance from the CRZ2. That is the authority, my lord, that the respondent number 2. Now, my lord, my case is, my lord, on 24th of January 2020, I applied. You have asked for a recommendation and status report in performa. The authorities have furnished you. Thereafter, you sit tight over the matter for near about 5 years. By that time, that area comes within CRZ2. Now, my lord, same area, same survey number. Other persons are running. My lord, my land which I have got on lease, that is survey number 90. And my lord, in paragraph number 28 at page 15 of my writ petition, I have categorically stated that in the said area, this operation is still in existence and none of them are having any CRZ clearance. My lord, page 15, paragraph number 28. Now, my lord, 2 of such operation is in the same survey number. Survey number 90. One and two, if my lord sees, one exclusively in survey number 90, another survey number 90 and 20. And my lord, these all are in same village, same locality, one after another, my lord, it is. Now, my lord, first, my lord, it's a clear case of discrimination. If you have allowed others to operate it, why you have stalled my application from last 5 years? Now, my lord, may kindly see, I will show 2 documents, my lord, and thereafter, first, my lord, I will show, my lord, the notification, my lord, page 29.
Yes.
My lord, this notification was framed under section 5 of the Environment Protection Act, 1986. If my lord sees second paragraph, my lord.
Yes, seen.
Now, my lord, this notification is exclusively for running a stone crusher unit.
Is it still in force? Wasn't there a recommendation in 2019?
No, this is still in existence, my lord. Now, my lord, it says, my lord, these are the parameters, my lord. It says distance from irrespective of nature of issues shall not be allowed to establish. My lord, these are formalities I fulfill because there is no departure from this fact. They are not saying, no, my lord, I will now place their letter and the recommendation. Now, my lord, may kindly come to page 37. Only 2 letters I will
They have
show.
asked for a clearance from the respondent number 2.
Respondent number 2.
Have you applied to the respondent number 2, or you are challenging that requirement?
No, my lord, my clearance ought to be from the pollution control only.
Pollution control you have already got.
No, I have not got. Only pollution.
Oh, you are asking that pollution. Pollution control is asking for that clearance.
That clearance. Now, my lord, pollution control at page 37 writes a letter, page 37. My application is of 24th of January 2020. On 18th of May 2020, pollution control writes a letter to the authorities, deputy commissioner. It says the Andaman Nicobar pollution control has received an application on 24th of January 2020. Sri Palsami seeking consent to establish a stone crusher unit at Dukshabad so and so. Name of the operator, survey number, my lord, may kindly see survey number 90. Land is taken on lease for a period of 15 years. I am directed to request you to intimate the land status and recommendation of district administration as per the new guidelines prescribed by the Andaman Nicobar Registered Notification dated 3rd August 2017, copy enclosed, and also take the view of the local people of the area to avoid any public complaint and submit the report. A format of recommendation and land status for the so-and-so is enclosed for ready reference. Now, my lord, on the basis of that, a no objection was issued by the area councillor that the public have no issues, my lord. Thereafter, my lord, may kindly come to page 40 is relevant. The revenue authority took 2 years to give this report. Now, my lord, this report says 18th April 2022. It says that query application so-and-so submission of status report. Now, my lord, everything has been stated. My lord, these are the requirement. If my lord sees clause 4, 5, 6, these are the requirement, my lord. And thereafter, my lord will find
The coastal zone is a different regime. CZR are a different regime. It may be required under that. May be required under that irrespective of this also.
yes, definitely, my lord, definitely. I will come to that. I say that paragraph 15 is the recommendation.
Yes, we've seen that.
Now, my lord, I say that I applied on 24th January 2020. My lord,
The
this-
first part I understand that 5 years is elapsed, you sat tight and therefore you let it come in the zone.
yes,
But as of today, Mr. Kumar, we cannot brush aside the requirement if there is any.
yes, yes.
So even if it's their fault, you can file for damages against them. We don't.
My lord, there are two parts.
Yes.
My lord, my second argument is that this is a clear case of discrimination. My lord,
So that is there.
yes,
So that-
single chunk of land.
but there is no negative equality. If you
Yes,
find that there is a requirement, then maybe the others will also be appreciated. But you have to still.
Two persons running in the same survey number, same land, they
Yes.
are allowed to operate.
That may at best show that it is not required, prima
Yes.
facie. But if they show that it is required, Mr. Kumar, you know under Article 14 there is no negative equality. Two wrongs don't make a right, basically.
My lord, my
There may be
contention-
7 persons, 8 persons who are running illegally. That does not give you a right, negative right to have similar equality. So they have to show that
Yes.
Stonecutter this.
And
CZR
it's
2.
cleared, my lord. If suppose, my lord, can you visualize the situation on 24th of January 2020, I applied. If they could have in time accorded this approval, my lord, I could have been allowed.
That is what I am saying.
Yes.
That you can at best be entitled to damages against them. But you cannot change the position as it stands today.
And my lord,
No, what is the offending letter? The last letter by which
yes,
they
yes.
page 43.
Yes, my lord. My lord, may kindly come to first. This was page 43, my lord.
43. Yes.
Page 43, a letter was written whereby it says, so and so is furnished by you pertaining to false fittings are as per the approval, so and so, so and so. This is the letter. And thereafter, my lord, in the next letter, they say you apply for clearance of CRZ. Page
Yes.
19 February 2025, after this.
Let us find out from you are for the pollution control board.
No, now one more thing, my lord, they are relying upon a notification. I say, my lord, for the purpose of operating stone crusher unit.
That notification does not say that CZR 2 is required.
No, that
That does not say.
does not.
But still, it may be otherwise required. We'll just hear.
I am just placing, my lord, that because my London friend is placing 2011 notification.
CZR 2017, yes. 2017 is with you. Oh, yes, he had already handed over.
2019.
So this was 2011. Sorry.
2011, I say it's not applicable. This is 2019 for my London friend.
Now.
They are relying upon 2011.
No, 2019. That is what I asked you. That
Yes,
in there
29. I say 2019. My lord, may kindly come to.
I said 2019. You said no. There is
No,
27.
my lord, I said 2019. My lord, I handed over on the other day, my lord.
No, did not hand over, but you mentioned.
My lord.
Yes.
My lord, may kindly see, my lord. Now, therefore, first page, my lord. Now, therefore, in exercise of the power
Yes.
conferred on so and so of so and so, and in superstition of the coastal regulation zone notification 2011, which was relied by my letter friend.
So this does not carry any CRZ 2. Let us come to CRZ 2.
My lord, may kindly come to clause
2.2.
2.2. It says CRZ 2 shall constitute the developed land area up to or close to the shoreline with the existing municipal limit or in other existing legal legally designated urban area which are substantially built up with a ratio of built up plots to that of total plots being more than 50% and have been provided with drainage and approach road and other infrastructure facilities such as water supply, sewerage, main, etc. So, my lord, this is CRZ2. Now, my lord, can we come to 5.2? The activities in CRZ2.
Yes.
It says activity as permitted in so and so shall also be permissible in CRZ2 insofar as applicable. Construction of building for residential purpose, school, hospital shall be permitted only on land, only on the land side, landward side of the existing road or on the landward side of existing authorized fixed structure. Thereafter, my lord, building reconstruction and all, to my understanding, it is not applicable. I will show why it is not applicable from the annexures. The annexures are there, my lord. I will place those annexures also. Now, my lord, you kindly see clause 6 thereafter. My lord, clause 6. Coastal zone management plan. It says all coastal states and union territory administration shall revise or update their respective coastal zone management plan framed under CRZ 11, number 6th January 2011, as per the provision of this notification and submit to the ministry for approval at the earliest, and all the project activity attract the provisions or the notification shall be required to appraise as per the update so and so, so and so. Now, my lord, can you see? Clause 8, my lord. Clause 8, my lord.
But your stone crushing unit is not, does not come within the permissible activities also.
Yes. Yes, my lord.
See, 5.2, the activities permitted, there is no mention of any sort of manufacturing or.
My lord, can you come to annexure first, my lord? Because in annexure it has been stated what all issues can be taken into. Annexure, different annexures are there. My lord, we get it from page 43 of the said.
Yes, 43.
43, my lord, will find annexure 1. It says conservation, protection, and management framework for ecological sensitive areas. This deals with that. Now, my lord, this is not attract in our case, my lord. Now, my lord, can you see?
No.
Thereafter, annexure 2 is at page 46.
Yes.
List of petroleum and chemical product permitted for storage in CRZ, except CRZ 1.
Not applied.
Not
applicable.
Now, my lord, annexure 3 at next page, my lord. Guidelines for development of beach resort, hotel,
Also not.
and tourism.
Development, no, this is not.
Thereafter, annexure 4, my
This is a demolition project. Yeah.
Annexure 4, my lord, guidelines for preparing coastal zone management plan. Demarcation of high tide line and low
This
tide
is
line.
different.
This is different.
This is regarding the demarcation.
My lord. Thereafter, my lord, because these are the requirement in terms of the provisions which are there in the notification, my lord. Each provision deals.
So the
with this.
difficulty is your activities does not come within any of the activities.
But at the same time, my lord,
there is no bar
there
specific.
is no bar. Page annexure 5, my lord, page 51. This project, no, my lord, these are the project, and annexure 5 said in this format you have to apply.
That is different.
No, my lord, annexure 1 to 4 are the project which can be undertaken with the leave of them, and annexure 5 says this would be the formality and modality.
Yes.
So, my lord, 1 to 4, my case is not covered. So, therefore, 5 will not come to so far as my case is concerned. So,
no, whether your this thing is totally prohibited, that you have to see.
Yes, my lord.
Because
No,
that
my
has
lord,
to be seen.
I will place, my lord, clause 8 also, maybe that may go against me, but
Yes.
I will place it, my
Whatever
lord.
goes against you, show those ones.
Yes.
So 8 is procedure for CRZ clearance.
Clearance for permission.
Provided it is permitted in the first place.
My lord, I say, my lord, so far as this is concerned, this is not applicable in my case. Now, my lord, I am showing the environment guidelines and stone crusher units, my lord. This issued by the ministry in July 2023, my lord. Clause 6, my lord. Regulatory monitoring mechanism for stone crushing unit. This is 2023, my lord. July 2023, my lord. It says stone crusher unit should obtain consent to establish and consent to operate CTO from the concerned so and so.
This is page?
Page 8, my lord.
Yes. Obtain consent.
Stone crusher unit should obtain consent to establish and consent to operate from the so and so unit. While applying the so and so should upload the unit field checklist attached as Annex 1 along with the digital tag photograph of so and so CCTV stone crushing unit. My lord, this, to my understanding, my lord, nowhere it says with regard to PRZ requirement, and the photographs, everything has been given, my lord. And Annexure 1 is also there, my lord. So, my lord, my contention is, my lord, there is no specific bar that stone crusher unit cannot be allowed to operate unless and until clearance is being sought for. Now, my lord, the forest department, that is the response number 2, has said it comes within CRZ limit in 25th of November letter, my lord. So, my lord, if my learned friend able to demonstrate before my lord that it's required, then
Yes.
With respect to 2019.
Switch it on.
Sorry. 2019. We
Yes.
say that notification is not applicable because if you want to import 2019, then there should be a coastal zone regulatory plan has to be there. It has not been done. It may not be kindly come to the notification that is 18th January 2019.
So you say the plan has not yet come.
Because it is in the instant notification it has been given. The Andaman Nicobar Islands and Lakshadweep was well excluded from it. Not be kindly come on. Fourth paragraph from the bottom. Now, therefore, exercise of the powers conferred under subsection 1 and clause 4, subsection 2 of section 3 of
Yes, yes, excluding.
it is in section 11 also it is excluded. That's why we are following proposal 11. So the coastal regulatory zone, the that MP has to be prepared, it has to be finalized. After this, only the 2019 will be implemented. Because we don't have the coastal zone mandatory plan at today.
All right. So what is applicable? 2011.
11.
So 11. Let us see. 11 has been handed over. Where does it?
here also it is excluded.
Here also it is excluded.
Yes, paragraph now, therefore, last 6 line.
No, 2011.
No.
Kindly come to.
Hereby declared the coastal stretches of Middle Andaman and all.
It's not coastal.
Such and such, and entire areas of Lakshadweep and their water up to and restricts the area. It applies to Andaman.
Yes,
No,
it's
but
not.
the law itself says excluding the island. Now, therefore, in exercise of power.
Yes.
Same thing has been said, my lord. Excluding the island of Andaman and Nicobar.
No,
and
my copy is not there.
2011, my legislation has handed over to Mandar.
6 January 2011.
This one. This one.
Yes, where is it? This.
This one. I don't know. They have how many they have added over.
They may have a different.
This was given to Rakesh only to me.
He's a culprit in both the cases.
Yes, same, my lord. In both
Ministry of
cases.
Environment and Forest. Ministry of Environment and Forest.
Yes. These are different.
Both are 2011. my lord. Which my letter.
This is also 2011. Look at this.
Ministry of Environment and Forest.
See. Actually, if it is in the forest notification, if it's excluded, the forest had no business to.
No, this one it was excluded. Now, my lord, it seems both are on the same day, but SO number is different. This has been that
So
one.
different departments.
Yes.
No.
No, department is same.
Same.
Same department.
Forest.
Forest.
Because it comes under the forest.
One is fraudulent. You are
This
the
is
architect of both.
This is like.
You have to
If
explain.
you are taking out this applicable, I come, Lord. This
Right.
is also mentioned. Lord, we kindly come.
No, this excludes. What is the Mr.
Yes,
Kumar?
this exclude. This exclude.
So we'll look into that today. You have to have a copy of this.
Lord, may kindly come to this file and it has not handed over to me.
So you should hand over this copy. No, I have to take back my copy.
Both.
That I can.
No,
That excludes. I've seen. If that is what they say is applicable, it excludes. But this does not carry any gazette notification to be published.
Yes,
Mr. Kumar, we cannot look into this. We have to go by the gazette notification. Sorry. At the top, it's written to be published.
Yeah, and that's
Cannot
Lord,
look
11 was published, my lord. 11 was published.
Cannot look into this. No, it was given by you. As I keep it and
Yes.
take a note that to be published.
But this is the 2011 which was published, not the gazette notification.
What is that?
Big one.
I have only this of 2011. But that excludes.
Yes.
So you can keep it. It is also excluded from my file. None are applicable giving the pollution certificate, Ms. Das.
Lord, may kindly read both for 2019.
Both exclude Andaman and Nicobar. I'm sitting in Andaman and Nicobar deciding the circuit which how can I ignore?
No. That is a different exclude. This is not the that element. Lord, may kindly come to read that.
The entire thing is excluded.
No. Now, therefore, if Mirror will see the central government into the landlord certification by local
But that copy has not been given by you to me.
This is a please not want
Not a question of my wanting. I have to, if I have to decide, I have to. But you are relying on that. It's your copy. There's no extra copy you have.
No, I
Then you won't have any copy. Share to direct. These are Kumar Brotherhood.
yes.
Neither of you are actually Kumar, are you? No. In real life, are you still Kumars?
My brother is
You're?
familiar.
No, not that. I was asking something else.
Lord, may I read?
Yes.
But the third paragraph, my brother is saying it is excluded. I want to kindly see what are excluded. Excluding the islands of Andaman, Nicobar, Marine surrounding areas after situation and location to restricts to setting up an expansion of industry, operation of process, manufacturing, handling and storage of people of other subfunctions as specified in other substance, handling, management and transferably movement rules 2006 to the office of CRZ. Not with that kind of read from 2009.
No, Mr. Rakesh Kumar, it says does hereby declare the coastal stretches of the country and the water area up to its territorial water limit, excluding the islands and the marine areas, and restricts the setting up of expansion of any industry, etc., such and such. So this does not apply to the islands. For the islands, there are other rules, at least 2-3 notifications are there. One forest notification, you must forest rules.
Yes.
One is wildlife rules.
Not if that apart, not if
Island rules, island protection regulations are also there. IPR, IPZ or
then how you have to protect the cultural heritage is here.
yes.
Not make kindly.
Let us see from this. Yes. So this is expansion of new industries.
In the act itself, it is provided.
Which act? Environment
The Air
Protection.
Pollution Act. The Air Pollution and Control of Pollution Act.
That will require only pollution control board certificate, but doesn't require a CSZ to clearance.
No, I mean to say that if you want to establish the pollution control certificate is mandatory because
They have asked for a pollution control certificate. You are refusing only on the ground that they don't have CRZ2 clearance.
but CRZ 11 is applicable because based on CRZ 2 has been notified and it has been only after the coastal zone management plan has been prepared, it has been notified.
But from this, it does not appear this has been notified by the central ministry, by the union government.
But it is only to the extent the mandatory and the shortage of disposal hazardous substance rules for 2009.
The coastal government with a view to the central government with a view to such and such conserve. There must be some other regulation for the Andaman zone, Andaman and Nicobar and Lakshadweep. There are at least four other regulations, rules. I mean, I cannot recollect right now. I was going through those. There are at least 4 or 5, 6 other regulations which govern Andaman and Nicobar. That's why this has been excluded, because those govern Andaman. They are separate for Andaman and Lakshadweep. No, it's clearly not applicable. You're right. Because excluding comes in the middle, separated by 2 commas. And it clearly says that just see declared the coastal stretches of the country and water up to territorial limit excluded as coastal regulation zone. So therefore, apart from Andaman and Nicobar and Lakshadweep, other coastal territorial limits, it's very clear. That comes with 2 commas both sides, the exclusion part. So the sentence continues as declared the coastal stretches of the country and water area up to its territorial water limit as coastal regulation zone, excluding Andaman. You have to have a proper. If you have been acting on this, then you have been. No, this is not applicable on the principle. You have been taking days accommodation, and the court's time is wasted. Did I narrate the facts on the previous occasion? No. The limited challenge in the present. No, that's just other result for. The limited challenge in the present matter is that the petitioner seeks to set up and operate a stone crusher unit on a land let out to the petitioner, comma, having a measurement of about 1000 square feet. To some learned counsel for the petitioner submits that the petitioner obtained such lease by spending about ₹10 lakh on January 20, 2020, and thereafter applied on July 24, 2020 to the Pollution Control Authority to get appropriate pollution clearance to operate such unit. However, comma, on some pretext or the other, comma, the pollution authorities did not grant such clearance. Initially, comma, a revenue report was sought by the revenue authorities, which was submitted in the form of a status report, comma, recommending the issuance of a pollution control certificate in favor of the petitioner. Subsequently, the pollution control authorities sat tight, comma, informing to the petitioner thereafter that an online application was necessary. Even thereafter, comma, certain further clarifications were required from the petitioner. Next para, after the petitioner crossed all the above hurdles, comma, the pollution control authorities, comma, apparently at the instance of the forest authorities, comma, asked the petitioner to obtain a CRZ2 clearance from the respondent number 2 authority. Next para, learned counsel for the petitioner contends that after having sat tight over the application of the petitioner for over 5 years, comma, allowing the concerned area to come within the CRZ Roman 2 zone, comma, it does not lie in the mouth of the pollution control authorities to insist now upon such clearance. So that apart, comma, it is submitted that the petitioner is only governed by the notification dated August 3, 2017, with regard to criteria stroke guidelines for setting up of stone crushing units in the Andaman and Nicobar Islands, comma, within the four corners of which, comma, no CRZ2 clearance is required. Full stop. Even otherwise, comma, Learned Council cites the environmental guidelines for stone crushing units published in July 2023 by the Central Pollution Control Board, comma, Ministry of Environment, comma, Forest and Climate Change of the Union of the central government, comma, where clause 6.0 provides the provisions contains provisions regarding regulatory stroke monitoring mechanism for stone crushing unit. Full stop. Even the said provisions do not require any separate clearance to be taken under the CRZ2 Roman 2 regime. Full stop. Next para. Thus, comma, it is argued that the insistence of the Pollution Control Authority on such clearance is not supported by any law or regulation. So next para, Learned Council for the Pollution Control Authorities seeks to place reliance on the Coastal Regulation Zone Notification dated January 6, 2011, issued by the Ministry of Environment and Forests. Full stop. However, comma, outset, comma, Learned Council for the petitioner points out that from the preface of the same, it is evident that the islands of Andaman and Nicobar and Lakshadweep and the marine areas surrounding these islands up to its territorial limit have been categorically excluded from the purview of the said notification, comma, which expressly appears to the court as well. Full stop. In such scenario, comma, Learned Council appearing for the Pollution Control Authorities seeks an accommodation to take instruction as to the applicability of the Coastal Regulation Zone Notification and or other similar notification to the islands. Full stop. For such limited purpose, comma, the matter is adjourned for the day and shall be listed next on April 27, 2026 under the same heading. Same heading means top of substantially hard, Mr. Rakesh Kumar, so we will. Only this point only. If it's not necessary, then obviously you can't insist. I'll ask you to give a certificate. This is more academic than adversarial, actually. No. Okay.
Item number 98. Here are 23 of 26.
Your Lordship, I am appearing for the petitioner. Your Lordship, it's an application for watching the criminal proceedings. I am submitting the photocopy as directed by the Honorable Court of the entire charge sheet. The photocopy.
Civil or what?
Your Lordship,
Either no offense disclosed or civil in nature. These are the two very civil. Yes.
Your Lordship, may I submit the brief facts of the case, Your Lordship, as alleged. Your Lordship, the petitioner herein happens to be power of attorney, holder of a proprietor.
Give me half a second.
Yes.
Sorry, please continue.
The petitioner herein happens to be power of attorney, holder of proprietor of an enterprise. That particular enterprise entered into a tender contract with the Andaman Public Works Department. And as per the particular contract, the said enterprise was given the duty to carry out electrical works. So as per the contract, the particular company was carrying out certain works of electrical repairing and all those things. Now, on 5th of November 2025, one of the employees of that particular enterprise, that is because that petitioner here is the subcontractor and the principal employee here is the APWD department. So because of that subcontract, the electrical works are being now carried out.
So you are carrying out through your agency, it is being carried
Through
out.
the agency, being the subcontractor.
So not a mere power of attorney holder, but a subcontractor as well.
The subcontractor is the actual proprietor of that particular enterprise, and the petitioner here is the power of attorney holder of that subcontractor.
Oh, you are referring to the proprietor as the subcontractor?
Yes,
Oh,
yes. No, Your Lordship. On the date of the accident, what has happened? Bhaskar Rao is the person who is the deceased. Bhaskar Rao was the
employee, that
person,
employee is Bhaskar Rao.
employee Bhaskar. Bhaskar Rao went to the work site. After that, he called one of his friends, K. Haridas, to that particular work site. So as to carry out the work, both of them climbed up on the aluminium ladder. The person who is the friend of Bhaskar Rao, that is the deceased, K. Haridas, he was not an employee and nowhere related to these works. But he was called on the instance of Bhaskar Rao, and both of them then climbed the particular aluminium ladder to carry out the repair. Now, in order for their conveyance from one portion of the ceiling to another, Bhaskar Rao, on his own will, he used wooden battens. He laid down wooden battens to transport himself from one portion to another. So both of them,
It is an aluminium ladder.
and through the aluminium ladder, both of them climbed on the ceiling.
Yes.
Now, from going from one portion of the ceiling to another portion,
The ceiling was unconnected. There were gaps.
there were gaps. So they had used wooden battens. So instead of getting down and again going through that particular aluminium ladder, these people, what did these two persons did is they
At the
used
top, they put
the wooden battens, and now they tried to get themselves transported from one particular portion of the ceiling to another. During this period, what happened? The friend, he slipped. And in order to save that particular friend, that is the deceased person here in Bhaskar Rao, he tried to help him. Both of them fell down on the ceiling, wooden battens broke, they fell on the ground, and at that particular point of time, both of them got injured. Bhaskar Rao was taken to the hospital along with K. Haridas, that is his friend. During the treatment, Bhaskar Rao expired. So, due to this particular incident, the prosecution has alleged that since the petitioner herein was a contractor, so the petitioner herein had the duty to ensure the safety, and in terms of the contractual agreement, there is one particular clause. I would place that clause before Your Lordship. The allegation has been shifted to the petitioner, and section 1061 of the BNS has been implicated. That is 304A of the erstwhile IPC, causing death by negligence.
BNS. BNS. Give me half a second. Let me just go through that section. 1061.
1061.
Wait, yes, got it.
May I place the section, Your Lordship? Your Lordship, whoever causes death of any
No, you
person
said yes.
by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. And if such act is done by a registered medical practice, the second limb will not apply because that is specifically for medical practice. Now, Your Lordship, here the mandate is there has to be a rash and negligent act. Now comes the doctrine of causa causans, which is, Your Lordship, in order to make a person liable under this particular section, there has to be a chain of causation whereby the act should be of such rash and gross nature and negligent nature that it must have a direct proximity with the accident that has been committed. Now, what happened on that particular day? The act of the deceased person using the wooden battens to get himself conveyed from one portion of the ceiling to another is an unforeseeable thing. That cannot be foreseen. That cannot be expected by the petitioner who was not even present at that particular spot. So had the case been that the petitioner being the supervisor would have been present at that particular spot, and upon his instructions, he would have climbed that particular ladder, and upon his instructions only, he would have conveyed himself from one place to another using the wooden pattern, then there could have been a possibility of proximity. But here, the petitioner accused, he was not at all present at that particular spot during the time when the accident took place. Now, Your Lordship, in terms of this doctrine of causa causans, there is no proximity. First of all, there is no act itself. There is no act that has been committed by the accused. The allegation here is the petitioner did not provide the necessary safety equipment. So far as the complainant statement goes, There is no such specific allegation only with regard to safety equipment because the
So at best damages. At best damages. Compensation or damages at best. So
Now,
that's
Your
why
Lordship.
civil.
Yes, Your Lordship.
And
Now-
no direct nexus, therefore this does not disclose anything
Yes, Your
against you.
Now, the clause of the contract which the prosecution has relied in order to establish the causation of this particular accident upon the petitioner, that has to be looked at. Now, Your Lordship, page number 122 of the charge.
Yes. Yes.
Yes, sir. Here, clause 32.
Right.
This is the clause in which the prosecution has placed reliance. May I place this clause, Your Lordship?
Mhm.
The contractor will be fully responsible for any.
You are not the contractor, you are the power of attorney.
Power of attorney. This is also one.
So agent, not principal.
Yes, sir.
So let us read.
Yes, sir. The contractor will be fully responsible for any accident or mishaps involving workers engaged by the contractor, and the contractor would pay claims made on this.
Exactly, that is what.
Next, Your Lordship, the contractor shall indemnify the department from any claims arising out of accidents, disabilities.
Yes,
or
Mr.
sicknesses.
Ilang, I have seen it. Yes.
This totally.
Do you
picturizes-
have you annexed a copy of your contract with the principal contractor?
Yes,
Is it
sir.
there
This is that contract itself. This is that contract
between you and?
between the petitioner and the APW department.
Acha.
This is
There
the
was a direct contract.
direct contract.
So you may not claim mere agency. You had a direct contract with the
With
with this
department.
APWD.
Yes, sir. The nature of the contract is that, Your Lordship, the department is the principal employer, I am the subcontractor, and he is an
But still, you had certain liabilities. Contractor is you.
Yes, Your Lordship. Now, Your Lordship, the contractor shall indemnify the department. So, whatever liabilities that arises
The
from
contractor
this
is that
particular
enterprise.
enterprise, and I am the power of attorney holder of the proprietor of that enterprise. Yes,
So
Your
if
Lordship.
at all, then the proprietor of the enterprise may be called up.
Yes, Your Lordship. And even then,
And that too for damages only.
that too for damages,
Or
because this is an actionable claim under law of torts.
Let us see the charge. The worst thing against you, let us see that.
Yes, Your Lordship. Page number 13 is the concluding portion wherein the allegation has been.
Yes. You are the only accused.
Only. It starts from the third paragraph, Your Lordship, as per investigation conduct.
So that contract you showed is between you and the APWD or the enterprise and the APWD.
Enterprise and APWD, but I have signed because I am the power of attorney holder.
Still, power of attorney empowers you to do what?
Power of attorney has been
We
annexed.
also have to see that.
Power of attorney has been annexed. Page number 142.
We'll see that and then come back to page 30.
Yes, sir.
And do all the official works in respect of firm like tender work, submitting bills. No, this is different. Sign all the procedure. This is the official work.
This is the problem.
And that was general power of attorney. The contract is that is 123 years. Yes, let us come back to 13.
Yes, sir. Page number 13, it starts from
Your
the-
name features first in the last paragraph of page 13 or before
Yes,
that?
yes, sir.
Before that, it's entirely the story.
It's entirely the story and the statements of the,
Nothing in respect of you before that.
no, just the statements.
That has come from last paragraph of page 13. You appear in this one. By his firm, you say. You admitted that the work was being executed by his firm.
That is the statement given before the.
You have given the statement that the disease was engaged by him. Even otherwise, you have the other points are very strong. But just we are just trying to get
Now-
over this part of it.
Yes, sir. Now, one more thing, he had neither visited the.
Yes, yes,
website
these are
of
there.
this, because the judgments which I will be relying upon later on, that particularly points out to the supervisor visiting on.
The question is whether negligence can include negative acts also, omissions also,
Yes, sir.
or only acts of commission.
And that too when there is no.
No, this
proximity.
would be an proximity is one of the factors.
Yes, sir.
But omission, doesn't it come within negligence also? Suppose somebody's, I mean,
Omission comes.
So
under
somebody
negligence
asked me-
by law of torts. Under law of torts, it comes.
no, broadly, that is rash and negligent act.
But
Suppose
in
there
order
is no proper support in a ladder. I'll give you a rough example.
Yes, sir.
No proper support, ladder is very shaky.
Yes, sir.
I ask you to hold it and I go up. You leave it. You don't hold it. That is also rash and negligent act.
But that.
Act can
Yes,
also
sir.
be in abstention from any act.
Yes.
But this is too distant. I mean, you are
Yes.
not present there, maybe.
First of all, the doctrine of causa causans is not satisfied.
all the
And
other
secondly, there is causa intervenient. That is, his friend was also present. Both of them climbed on that particular wooden pattern.
No,
And
caution.
in order to save his friend, both of them then.
If you are present, it will be very difficult for you otherwise, because it is a subject of investigation whether for their own act or you did
Yes,
something. Or
But
something.
here there was no presence of the petition.
And previously it has not been alleged. Your name is not there, so it was not alleged by them also prima facie that you were there.
Yes. No, the complainant himself states that I was not there. Only those two people were there. That too on a public holiday.
So what is the case made of things?
The case is made out under section 106(1) of the BNS.
Where is it stated? I mean,
Yes,
this
sir.
chart sheet. Accused. So you are the proverbial scapegoat actually. For the offense punishable under 106 arising out of gross negligence. So page 14, the second paragraph above that list. Yes, anything else, Mr. Lago?
Yes,
Seen
sir.
this, sir.
Their option, I would say reliance on some of the decisions. First is the decision of this division bench of this on the court. Relevant portion, page number 3. Page number 3, para 6. The mere fact that an accused contravenes certain rules or regulations in doing of an act which causes death of another does not establish that the death was the result of rash or negligent act, or that a person may be guilty under section 304A. The rash or negligent act should be direct or proximate cause of the death. The next portion, Your Lordship, next page number 7. In our view, no materials have been disclosed in the FIR which would prima facie indicate that any act of the petitioners was the direct cause of the death of the workman. On the other hand, over the self-same incident, being case number 82 of 1983 was instituted against the Usha Man Industries, so and so. The averments in the said petition will unmistakably show that the present petitioners had no connection whatsoever with the alleged incident, and as such no complaint was made against them in the said case. It appears from the said complaint that the chief electrical inspector of the government of West Bengal upon inquiry observed that the persons named in the said complaint were responsible for committing breaches of the rules. No materials have been placed before the court to show that ingredients under 304A of the IPC have at least prima facie been satisfied in the case, apart from the fact that the accused were at the material time administrative manager, supervised and general manager, respectively. There is no averment that the death of the workman was the direct result of any rash or negligent act of the accused, and it was the causa personalis. Next is the decision of the Honorable Apex Court, Your Lordship. Failure to provide safety equipment. Deals with failure to provide safety.
Don't cite too many.
Your
Selective judgment.
Lordship. Page number 3.
Hmm.
The beginning paragraph, second line. It was stated that the appellants did not provide any safety equipments like belt, helmet, rubber shoes, etc. to the two deceased employees. So here also the allegation is the same. Now the relevant portion is at page number 9, the last page, paragraph 17.3. Insofar as facts of the present case is concerned, the two deceased employees of the appellant were undertaking the work of decoration of the front side of the shop. As part of the said work, they were working on the signboard, which was approximately at a height of 12 feet from the ground level. For this purpose, they were provided with an iron ladder. While working on the signboard, they were struck by electricity, as a result of which they got electrocuted and fell down, resulting in multiple injuries, resulting to death. It was purely accidental. On these basic facts, no prima facie case can be said to be made out against the appellant for committing an offence under 304 ARPC. And here there was another allegation also under 304 Part 2 of RPC, but in my case it's not. I have other judgments of the other high court, but your lordship has not.
Yes. Yes, Mr. Karmakar.
Please.
You give him space. You come this side. Principal again, both come this side. Yes. Yes. Yes, Mr. Karmakar.
Washing of fellows. Of course, if there is no privacy evidence, washing should. That's why I am admitting that position. Settled principle. Here from the charge sheet, what is the allegation?
Yes.
The petitioner is the power of attorney of his own mother. Mother is the proprietor, original proprietor. Being a first legal heir, mother and son, they are the beneficiary of that farm.
It's not a suit for inheritance.
No, not inheritance.
Mother, father,
father-in-law.
son.
It can be presumed not she mother is the proprietor. Old lady always used to give a power of attorney to execute a work for getting some benefits in
You're
business.
trying to save the mother by
No, I
getting this.
am coming to that. So I asked you clarification that what is the nexus with this
Right.
petition with the crime. So mother, original proprietor, admitted position. That is the proprietor, and he is also a power of attorney, the petitioner. What happened? Two laborers were engaged because the firm has got a tender from APWD, that is a department, government establishment.
Mother's firm has got.
Firm. Being a son, power of attorney, his duty to engage laborers and completion of the execution of the work. Workplace is hardware, little enough. Firm at Port Blair. Tender was given, agreement was done. Then he engaged two laborers. My learned brother has said one laborer and another was friend. So workplace at Hardwick in the ice plant of Fisheries Department. Proceed. Petition after execution will of course raise a bill. You will get in the financial benefit for that execution of the work, being a power of attorney, and the mother is the proprietor. His duty. What is the section 106, Lordship? Kindly again carefully. Whether it is a rash and negligent or rash or negligent. That has to be seen. 106. Because in judgment I found somewhere little rash and negligent. So he is liable to be discharged. Kindly see, whoever causes death of any person by doing any rash or negligent act. Now, Lordship, of course, what is the meaning of particular word of negligence? So if I say, as per my little knowledge, Lordship, any careless act is a part of the negligence. Any careless act. What was the careless act of this petitioner? This honorable court has to see from the case of the charge sheet. It is admitted my brother has submitted that I was not present in the place of offense. So again I am saying place of execution of work at the hard way. What was the duty and the responsibility of the petitioner regarding the engagement of the laborers, regarding the physical position of the execution place, what was the condition of that structure, whether the safety equipment is to be provided
provided to the laborer who will execute a work. It's all a casual act of the petitioner. He never visited to the place of occurrence. Only execution of the work he engaged one laborer. Admittedly, I am not deny that two laborers were engaged. Admitted one laborer was engaged. He was not present. Work was executed. During that work, without providing any safety equipment, without verifying the execution place, over telephone, he engaged labor, execution of works, this has to be done, this has to be done. It's a negligent act of the petitioner because the workplace is connected to the electrification in the ceiling area. So, here 106, I am not on rash act. I am on negligent part only negligent part. Casual act, of course, the attraction of section 106. So, he himself admitted that I never proceeded to the execution place. Over phone, I have engaged the laborers. It is also admitted by my learned friends. So, not attending, not verifying the place, the condition, without giving a safety equipment, of course, the attraction of section 106 of new act, that is BNS 2030. For that reason, charge sheet was filed. Two laborers, one expired, one got grievous injury. He referred to the hospital as GB Pants Hospital. If my learned friend says that no direct nexus, not required at all, my negligent act have been clearly established from the face of the charge sheet. Because it's admitted I was not present on the spot. My duty, what is my duty, Lordship? If suppose in my house, I engage some laborers connected with electrical work. Of course, it is my duty and my responsibility that what will be the procedure because they connected with the electrification. Being a owner of my house, I have to see some whether equipment, safety, gloves, and other things have been provided to them.
Remember that the next time when some electricity.
Lordship, I always used to.
You used to provide gloves to the.
No, I instructed them.
He must have instructed also.
No
Wear
record,
gloves.
no record at all. He admitted I never visited to the place of execution work.
On that day.
But for that criminal negligence.
Lordship, of course, because rash or negligent, not and.
No. We are going only on
Only negligent.
That I can appreciate.
So
fully.
what is the meaning of negligent, Lordship? As per my knowledge, casual act. Because he is a farm, not a small farm, not a work related to any domestic houses. It was farm. He used to do this type of work, getting business benefits, profits.
What about these judgments which say there has to be a
Lordship,
direct nexus?
Direct nexus, Lordship. Here, regarding negligent part, in my case, there is a direct nexus. There is a direct nexus. Because if I submitted negligent, casual act, that is established from the face of the charge. Regarding other 304 part 2, that is not out of second one, not applicable at all. Because we are on 106 new one. So my specific argument is that, Lordship, negligent is a casual act which has clearly established from the face of the charge sheet non-presence of the petitioner who has executed the work, who was getting the benefit, profits, he was not present on the spot. It was his duty to at least look the verification, the position of that workplace. That was also not done. That is admitted position. So at this stage, he has to face the facts. He has to face the time.
Yes.
That is my respectful answer.
Face the crime. No. Reply.
In reply, Your Lordship.
Mr. The public prosecutor is the crime, so you face it. He is the holder of. Yes.
Your Lordship.
Reply.
In reply, Your Lordship.
Negligence.
Yes.
Yes.
The part of negligence, Your Lordship. The negligence that has been brought forward now to the learned prosecutor, Your Lordship, that negligence actually amounts to a negligence under law of tort. It cannot become a criminal negligence
No.
until unless.
Forget tort.
Yes.
But here, yes, it may be a tortious act as well as a criminal liability also.
Yes.
There may be common grounds in it.
Yes.
But we are only on 106, right?
Yes.
So 106, Mr. Karmakar is saying this negligent act within the broader connotation of which your duty, you did not perform your duty by providing safety equipment, one, not being present there, two. So these also come in.
Your Honor, if that accident would have happened in a routine course of duty, then my negligence would have been established. But I cannot foresee that that particular person will call his friend and they will climb on wooden battens, and in order to save his friend, both will fall
No,
down.
but see, if it's a
And
fallout.
that too on a public holiday.
Fallout is a bad pun here, not intended. It's a bad fallout of it is one of the fallouts of, or one of the consequences or incidental things of his work. He was doing his work only. Falling, nobody foresees.
Yes.
But whether you not being present there and not providing safety equipment was one of the reasons for the fall. And the fall was during a time when he was doing his duty only.
But on that particular
Not that he
day,
was
there
on a picnic, he was in duty.
Your Honor, on that particular day, it was public holiday. There was no specific instructions taken from the petitioner to work on a public holiday.
This is a new ground you're taking.
Because that particular day is being cited, so 5th of November 2025 was a
No,
public.
that is a subject matter of
Yes.
investigation.
Yes, yes.
If we at all
Now,
hold
Your
you
Honor,
that
let the case be such that he would have fallen from the aluminium ladder, then there might have been some ground. Because it was a routine course, I was given
no,
the
it won't,
responsibility.
because when we do our work, we have to. I mean, we can improvise a little bit. I mean, to because there maybe aluminium ladder might not have been. So it's his negligence. It was his direct contributor negligence or your negligence. So that is a matter of investigation. So aluminium or wooden, but some plank or something. That is a subject matter of investigation. That is what. That is your stand. That is their
But
stand
that
also.
incident is not foreseeable. So as to be, so
No
as to
accident is foreseeable. But the question is whether you have taken proper measures to prevent it. That is the periphery of negligence.
But
No accident can be foreseeable.
yes, sir.
Direct nexus is a good argument. Direct nexus, you understand civil liability alternative. That's a good argument also. You're not being present there. No direct nexus is a very good argument. But otherwise, I mean, no accident is foreseeable. Otherwise, it wouldn't be called an accident.
Yes, sir.
Right. So falling down cannot be a. Even if he rode the aluminium ladder and he fell, it could be an accident. I mean,
But nature of
that is taking it a bit too technical.
Yeah.
That
Nature
wooden
of-
plank and.
Yes, sir. But nature of negligence has to be totally true.
Yes,
When
definitely.
is nature of negligence, when it becomes a civil negligence and when it becomes criminal. Now, Your Lordship, page number 86 of the chart.
Uh, 86 is a part of the chart sheet.
Yes, sir.
Yes. What about 86?
There is a problem in number 84. 84.
Yes.
Yes. Clause 18. List of mandatory machinery, tools, and plants to be deployed by the contractor at site.
Hmm.
There is no such allegation that I have not deployed any of these mandatory items. Because the work is not being carried out on a high-rise building.
It's an ice plant for fisheries.
Ice plant for fisheries.
So
And that plant is
access
maintained
to the
by
ceiling.
PWD.
Access to the ceiling may be necessary.
Yes, Your Lordship. For that, that is why it has been mentioned. List of mandatory.
Self-supporting ladder, yes.
Yes.
So this ladder was there.
That was there. That was rightly there. Now, Your Lordship.
Hmm. So insofar as this, he's going from one part of the roof to the other, there is no other equipment than self-supporting ladder required under this to have access to the roof.
So could have
So no, not
What
that
down?
like gig workers. I mean, those people who work in construction sites. There is no such requirement. Any framework or anything.
What down?
Steels.
went to the other portion.
They are agree that what tools has to be there. It is between APW. It can there condition. That is good.
This.
Yes.
That is what is bound by.
Yes. But
But
on physical, what was
you
found?
cannot take him beyond his agreement regarding the because your allegation is Mr. Kormokar not ensured, neither visited the work site nor ensured supervision or compliance with safety norms. Regarding personal visit, I don't find anywhere that he is required to be personally present there throughout the work hours. That is not supervision. Then he would be a worker,
But
not a
who
supervisor.
has to be now personally present, Your Lordship, that can be seen. Page number 53, Your Lordship, of the chart.
Yes.
Your Lordship, column 3.
Yes.
Details of departmental engineer or officer responsible for monitoring and supervision of the work at site. Shri Rakesh Kumar, junior engineer, was holding the charge of junior engineer.
Again Rakesh Kumar. I
As
can
Shri
handle only one. Who's
Bye.
there? He's not there. Oh, here. I can only handle only one in one side. So you are not required to be there.
Yes, sir.
So now, the next one, guys, let's do.
Safety compliance.
Next
yes.
one.
Let's see who will see contract.
Safety compliance, of course, by contractor, but
It is the equipment for execution of the work, Lord.
safety
Regarding
compliance
safety,
as per terms and conditions in
in
the
the
agreement,
agreement, the contractor has to follow the safety norm.
as later on in the agreement, specifically pertaining to the agreement.
Take up to 2. I'll pass orders. I'll keep it to 4 orders on Monday.
So, this is my.
Alright. Similar matter, my lord, as the direction was given.
Similar means to this. Similar to
No,
this.
no, my lord.
Your other matter.
In one matter, my lord has already given direction for affidavit. Today, 13 matters are appearing analogous matter, my lord.
Which,
So that case is
Which of the items?
serial number 46, 36 to 42, 45 to 49, and 51.
So, Mr. Kumar, can I pass similar orders in this? Write the item numbers. Ask your learned junior to write the item numbers in a slip of paper. These items similar. A copy to record.
Same hospital, item number 27. On the civil code, disposed by civil suit, pending for 6 years.
No, on Monday I'm sitting. Item number 27. You're not coming on Monday.
This for mediation report for 6 years pending to get the report.
27th, you're not coming at all. Come. Come on, friends.
My lord, may I be permitted item number 20? My lord,
Yeah.
I'm just seeking formal direction for service.
I'll do that on Monday. Because I categorically gave out that I will be sitting after 2. So if somebody is watching the matter, I'll definitely pass that order. Kota bhul achi, kota. I've reached up to 19, so I'll positively take it up on the next.
Well.
What of top fixed? One top matter. One top fixed. Top fixed is top. Well, hearing is concluded. Full stop. I'm reserving judgment on this. Judgment reserved. It is from me judgment. ये particular acne years. Thank you.